think I can record. I'm gonna try it, man. I'm gonna try. This is something new. So, okay. Let's see. I'm supposed to go live, but I don't see it. I'm not sure. It's interesting. I might be doing it wrong
No, it says
because
it
I.
says live, Chandan.
Yeah, but I'm not sure where does it say live, like where to, because I put it to where it should go live to Facebook, and when I go to Facebook, I don't see it there, so I don't know where is it. I don't know where it's going live to.
Okay, I understand.
Uh, and it says that there's one viewer. I wonder where they're looking from, but anyway. So
I'm
what I
gonna go
want
on
to
Facebook
share,
and
right?
look.
Huh?
I'm gonna go on Facebook and look to see if it's there.
All right. So what I want to share, right? I want to share so I get it on the record, right? Because I'm gonna put this up on the YouTube channel, and I want to mention about the acceptance for value, about how I'm interpreting it, and how I'm just sharing it, and see if the interpretation is met um, with with other people's perspective. So I wanted to also put this on the record. Hold on. Okay, so guys, what I finally did, I finally managed to get the certificate of trust for the living trust. Put it on the record. I got it in the court, and it's already recorded, right? So what I can interpret now is that the all caps, right? The person, the legal person, he is now a trustee of a living trust, a private trust, and according to how that's set up, the public, um, the public, sorry, the legal person, the all caps, has been conveyed from the public to the private. So now there's evidence and there's recorded in the courts that the all caps legal person is a trustee of a living trust, and therefore has full authority to manage the assets of the living trust, and basically has the powers and duties as trustee, which include but are not limited to collecting, holding, maintaining, managing, and administrating the trust property. Right? And I also, what I have on the record is a power of attorney from the estate to the living trust. So the living trust holds power of attorney over the estate. So this means, to me, this means that now I have authority as trustee to speak on behalf of the living trust to accept uh, any commercial instruments for value. And then I can now, if I'd like, I can use it now as an asset, and I can now deposit that to the treasury if I'd like to, or I can convey it to the treasury with instructions as a special deposit. Now, I have the paperwork that says that I can do this now. Before this, it's completely understandable as to why they would say, no, you can't do that. No, you have no right to do that. Because there's nothing really on the record. And they're basically going on presumptions, right? So the acceptance for value, I noticed that it requires us having to understand and to utilize the bills of exchange, right? And I've read the bills of exchange. And what I notice is that if you're a debtor and you have no assets, right? You're a debtor. How can you use the bills of exchange as a creditor? Unless you have power and authority and rights to use assets, I think you're not able to use the bills of exchange, or it's not going to be seen that you have the authority to do that. So it more and more makes sense now to get the status of that legal person as a officer of a private trust. Obviously, there's many ways of doing this, but it appears that this is going to be for me, it appears to be the most sensible thing to do. Because at the end of the day, if we are, if a commercial paper has the all caps name, obviously that's not us. And even if it doesn't have the all caps name, man cannot exist in the commercial world. Man won't be recognized. It'll always be that entity, and we are the representatives, and either we're competent or not to use that legal entity. So when it comes to acceptance for value that we're going to finish reading right now, I believe it all depends, right? How we come in, because if we're going to accept it as a public debtor, obviously that's different than accepting it as a private trustee who can manage assets for a private trust, right? Or a trustee who can manage assets for a private trust. So then now, let's say a bill comes, right? I get a bill from the utility company, let's say, that has the name of the public debtor, right? So now, as a representative of a private trust who owns all the rights, title, and interest of the public debtor, now the trustee of the living trust can come and claim that bill, right? Claim it. That's my debt now. And now can utilize that as an asset. And now can sign it, endorse it, assign it, transfer it, do whatever you want with it, do an order to pay. Now, yes, as a trustee who has the rights to utilize property of the debtor as an asset, now, yes, I believe that's how what we're supposed to eventually do is to change the status of that that legal entity. So I wanted to share that with you guys before moving on. So what we did, we were reading. Let me go to the presentation now. We were reading. Give me 1 second. Let me switch over to the presentation.
Just to let you know that they can connect. They just need to copy and paste it in the search bar, and then connect to you through Facebook. I tried it.
All right, really? Wow. Okay.
Yes.
All right. Interesting. Okay, here we go. Boom, let me. Okay, Eric is here too. Okay. Welcome aboard, Eric. So you're saying, Lorna, so you're saying that they would have to connect how again if they want to view this on
If you're on
they would
Facebook,
have
just
to
go press the link, and then you press the icon. It's like a three dot icon. Press on it, and it's gonna give you the option to copy it. You copy it, and then you take it to your search bar on your website, and then you put it in and search, and it's gonna take you to this website that we on right now, and connect you.
Oh, okay. All right, cool. I see you put it on there. Thanks a lot. I see you put it on there. Cool. All right, perfect. So what I'm gonna do, I'm gonna leave off from where we ended last week. And this acceptance for value, like I said, I think is gonna make more and more sense the more we read it and and understand what exactly we need to do on our end. So Let's see. Acceptance for value. Let me. Man, this thing is funny. Here we go. Okay, can you confirm that you're seeing what I'm seeing? It's page 24. It says since 1933, the only money. Can you confirm that that's what you're seeing?
Yes, we're seeing that. I'm seeing that.
Perfect, perfect. All right, so I'm gonna start reading, and then we'll get into it. Right. So since 1933, the only money in circulation in the United States is credit, borrowed from the people. The commercial code, adopted by every political state of the United States, provides for value to be whatever consideration is needed to support a mere simple contract. The president's oath is consideration sufficient to support the simple contract the president, which is the executive trustee, has with the people, which are the beneficiaries. He does not have an oath of office. That is different than an oath. All legislative, executive, and judicial officers performing under him in his capacity as commander in chief have oaths of office. He has a constitutional oath. See, and this is something that many of us are not aware of. And we didn't even know that there is a difference. We didn't even know there is a difference. So it's very, very good that this was able to point it out. So let's see here. My computer is tripping a little bit. Give me 1 minute. 1 minute, 1 minute, 1 minute. Okay, let me add somebody else in. Welcome on, Dati. I hope I'm saying that right. All right, so I'll continue reading. Again, we're going to leave off from we're going to start from where we left off last week. Okay, here we go. Acceptance for value. So, value. Value is anything recognized as a pledge or the result of a pledge. The birth certificate is the result of the president's oath. Without that one oath, the birth certificate would just be evidence of the obligation every United States citizen owes to the United States. Without that one oath, the birth certificate would not be evidence of the obligation the United States owes the people. On the public side, the birth certificate represents value and is evidence of a pledge by a U.S. citizen to be a surety for the United States. On the public side, it is security for the pledge of the allegiance to the United States and its statutes made by U.S. citizens. Now, on the private side, it is a receipt and is evidence of a promise made by the president to the people. On the private side, it is security for the promise of distributions from the trust to the people as beneficiaries. It is a receipt for the use of the baby's physical description that was symbolically delivered by an informant, which is mom, to the United States. The setoff resulting from accepting an instrument for value is a distribution from the trust. Setoff distribution. So let me just expand on this, right? So if I have control, right? If I have control over the assets, I'm a private trustee now, right? Let's say I'm a private trustee of a living trust. And I have control over the assets of Chandanmakhijani, the all caps. If I receive a bill, right? If I receive a bill of Chandanmakhijani, which is a promise to pay, it's an obligation, and I accept it on behalf of the trust, right? Now this piece of paper is part of the trust. It is now an asset of the trust, right? Now it's a share of the trust. I can now hand it over. I can now do something, use it as value, right? So on the if we are in control from the private side, we can take public debts and accept it as property for the private trust, right? And now we can utilize it. So this is what it means right here on the bottom. That's how I'm interpreting it. So the set off resulting from accepting an instrument for value is a distribution from the trust. So it's a part of the trust. So we're using that to set it off. How are we using that? Now think about it like this. This is how I'm interpreting it, right? So we get a bill from the utility company. The utility company and the bill, everything, it has an account number on it. So we accept the bill on behalf of the trust. Now that's an asset that we can now convey, and we can say, hey, use this asset, and I authorize to release the credits to be utilized for the principal account on the account of the utility company, so that it can be used to set off whatever's debt is supposedly in the utility company's account. So we're using the same bill, converting it into an asset, utilizing the credits of that asset so that it can be used for set off. So that's how I'm interpreting that. And let's get back to it. So acceptance. When you accept for value, you're accepting whatever consideration the United States has offered to you as evidence of an obligation it has to you as a beneficiary, as well as whatever consideration is offered on the instrument that is being transferred to you through the U.S. citizen you represent. The United States is humbling itself by asking you to give it assistance. It is applying for credit on every instrument that is issued or transferred for value. If you just receive one of these instruments without accepting it for value and returning it for value, the presumption is that you intend to pay it. You can pay it with a check, or you can pay it with your prepaid account. It is up to you. But you have to pay it immediately, or you will be deemed to be in dishonor. If you accept for value, you can use a distribution from the trust to pay the instrument. If you just retain it or argue about the existence or amount of the request, you will pay it with a check, tangible property, or your body. Did the United States offer a birth certificate to you? Did you receive it? Did you accept it for value and return it as a security? If you do not accept it for value and deposit it as an asset, you have voluntarily waived your rights to a distribution that is available to you. In a purely commercial system, rights are remedies. Parties to a modern commercial transaction need remedies in the event one of them breaches the terms of the agreement. The birth certificate is a remedy and represents an antecedent claim you have against the United States. It is also evidence of a pre-existing contract. It represents the prepaid account you have available to you for set-offs. Acceptance is an agreement and leads to a binding contract. If you don't set the terms of that binding contract, the United States will. Acceptance by silence. Acceptance of an offer, not by explicit words, but through the lack of an offeree's response in circumstance in which the relationship between the offerer and the offeree justifies both the offerer's expectation of a reply and the offerer's reasonable conclusion that the lack of one's signal acceptance. Ordinarily, silence does not give rise to an acceptance of an offer, but this exception arises when the offeree has a duty to speak. This is from Black Law's Dictionary. So obviously we want to make it clear. So I read this. Let me show you right here. I read this book. Well, I'm still reading it right here. It's a business law book right here, and it clearly states that all we got to do if we are in control of assets is just simply write accepted. We don't really have to say so much. We just, by saying accepted, it's already understood that it's being accepted for value. Let me see. 1 minute. Okay. Now, if you're acting like a U.S. citizen when you send your communications, they do not have to respond. You hear that? If you're acting like a U.S. citizen when you send your communications, they do not have to respond, and their silence is not acceptance. If you're acting like one of the people who are beneficiaries in the trust established by the Constitution and by President Roosevelt, they do have a duty to respond, and their silence is acceptance of the terms of the offer you make in your communication. A man can refuse to approve the application for credit inherent in instruments issued for value by the United States, but that might imply the man is an enemy of the United States. That is not good. It might be better for the man to approve these credit applications through acceptance for value and return for value. By signing and processing them properly, the man can avoid a trading with the enemy charge and at the same time fulfill a presumed moral obligation to aid and assist the United States in its time of emergency. Since 1933, the people have had a means by which they can have everything they want as beneficiaries of the trust created by President Roosevelt. A for V is a means by which the people can earn that beneficial position if they want to. They're not required to earn it, but they can if they want to. That is a personal choice. That's true because they don't really hide anything. They actually have everything in these law books and publications, and they're not really hiding it. It's written obviously in these legalese language, and it takes a little bit of time to understand it, but they really have everything in the open. So it is somewhat of a choice, I believe. It could be a choice, but obviously a lot of us can go our whole lives and never learn of this. So let's go back. It says offer and acceptance and counter offer. To form a binding contract with the United States through offer and acceptance, someone must initiate the negotiations. Either they will initiate or you will. The one who makes the offer is humbling himself and honoring the other party through the offer of something as consideration for the purpose of getting consideration from the other party. Consideration can be money, it can be interest in property, or it can be performance, which is energy, or anything that will support a simple contract. In modern commercial transaction, gold, silver, and things are not value, but promises can be value. Interest in things is value. The consideration on both sides must be equal for the transaction to be balanced. Value on one side, value on the other side. It's very interesting he said that. It says right here, in modern commercial transaction, gold and silver and things are not value, but promises can be value. Interest in things can be value. So there's consideration on both sides. Interesting. Your communication can establish by your actions, not your words, that you are one of the people. It should contain the instrument that was issued and transferred to you for value after you have accepted it for value. It should say what consideration you're offering, A for V instrument, and what you are requesting as consideration in return, which is a set-off, distribution from the trust. Public and private do not mix. So a request for a distribution from the trust would be like asking for, I have no idea what this word is, because it's like they don't understand what you're asking for. The public does not know anything about the distribution from the trust, but it does know about set-off and securities and entitlement holders, etc. Your communication should contain the terms of an agreement that will be a win-win situation. It should ask them to do something responsive to you as one of the people, not as a US citizen, but it cannot contain too much truth. It should not contain anything that connects you to benefits granted by the United States. Those benefits might be use of United States statutes, use of United States courts, use of United States judges' opinions, use of United States currency, use of United States license, use of United States officers, use of United States civil rights, use of United States rules and regulations, use of United States forms, use of the United States bonds, or use of the United States insurance, to name a few. Since 1933, American common law is not available to the people through the courts, but commercial remedies are available through the post office. Your communication should not contain anything that draws from common law remedies. The commercial remedies contain the principles of the common law that is needed to settle the account. The only system of commercial remedy available now is the law of nations, which is based on agreement using the law merchant. United States courts enforce agreements using law merchant. You have the power to negotiate agreements that are advantageous to you. Or you can let the United States set the terms of the agreements. That is a personal choice. Okay. Your communication, let me see, sorry. Okay, here we go. Your communication should state the terms of the agreement you are offering to the other party. You must have a delegation of authority to represent the United States. Your communication should be directed to someone who is authorized to bind the United States. Low-level employees of a corporation generally are not authorized to bind the corporation they represent. Just as low-level employees of the United States are not authorized to bind the United States. The president can bind the United States, though, and he has first-level agents who have delegations of authority to do that on his behalf. They are the heads of at least three of the executive departments: the Department of Homeland Security, that's the legislative branch, the Department of the Treasury, that's the executive branch, and the Department of the Justice, which is the judicial. This is a mini government within a government corporation. It governs under military rules using admiralty courts that implement the law merchant to satisfy the claims creditors have against debtors. Look for the Department of Homeland Security flag of jurisdiction at border crossings. It has a dark blue background with a circular seal of that department in the center. Since none of the members of the legislators or executive and judicial officers of the United States has the oath required by Article 6 of the Constitution, the only way they would have a duty to you is through the oath of the president, the executive trustee on the trust created by the Constitution and the trust created by President Roosevelt. His position as president, which is Article 2, Section 1, comes in the Constitution before his position as commander-in-chief, which is Article 2, Section 2. His oath is required in Section 1, not Section 2. If you act like a surety for the United States instead of a beneficiary of the trust, his officers have no duty to speak, and their silence is not acceptance. If you act like a surety for the United States, you have a duty to speak, and your silence is considered to be acceptance. When the United States targets you to give you a loan, you can, one, not respond immediately and pay later, two, refuse the instrument because it is defective, or three, use your set-off as a distribution from the trust. You cannot use the set-off if you're holding the birth certificate in a filing cabinet. If all you have done is take the birth certificate and have not paid, meaning performed, when asked to pay, you have waived your beneficial interest in the trust and have agreed to be liable as surety. That is a personal choice. Acceptance for value, taken for value. Hold on, let me see if there's somebody who needs to come in. Give me 1 minute. Yeah, there's somebody here. Let me add them in. There you go. Okay, perfect. Acceptance for value, taken for value. Issuing an instrument is not the same as issuing an instrument for value. Accepting an instrument is not the same as accepting an instrument for value. Generally, the issuer of an instrument is the one who has the duty to pay. If an instrument is issued for value, it appears its issuer is not actually the person entitled to enforce it, and may not even be a holder in due course of another enforceable instrument. He has no standing or demand payment. He has no standing to demand payment or performance. But by issuing an instrument for value, he might be able to open a new account through the transferee's unqualified taking of the instrument. If the issuer can get the transferee to take the instrument with no conditions on the taking, the transferee is waiving the defects in the instrument he is taking. The main defect is that there is no consideration attached to the offer to contract. There is no value in it at the point it is issued. The issuer is looking for the transferee to provide the value. The issuer is looking for the transferee to provide the consideration for both sides of the transaction. By merely taking, meaning accepting the instrument, the transferee becomes an accommodation party. He receives no rights, no defenses, and no value for his agreement to lend his name and his credit to the transaction. He does not realize that there is a hidden value in the instrument that he can use to his advantage if he accepts it for value and returns it for value. So what I'm getting from this is that, let's say we get an instrument. Again, let's go back to the utility company. They sent us a bill. Now, it appears that although they have no rights to the title, the interest, and they're sending that to us, it's not them that are issuing it. It's basically the all caps is issuing it, because when you see the bill, we see the all caps name right there, right? So we see that the all caps legal name, it's actually, and this is an interesting thing too, because I was open to the idea. I became open to the idea that whenever we go and apply for an account to be open, right, we're applying credits to that account. It seems that we're doing is like we're opening a bank with a new corporation. So with the utility company, when we sign the customer agreement, we give the social security card. So we're giving that social security, which is an account. We're giving the all caps. We're giving title. So we're giving a lot of stuff, and we're giving an agreement. So we're giving value. We're giving consideration. We're giving, right? So now, what we're doing too is that we're opening a bank, and that all caps. When we get the bill, it's actually being issued by the all caps. And now, again, if we accept it as a U.S. citizen or as a Belize citizen or as a citizen, obviously it's not, there's no standing there. You know what I mean? Because the U.S. citizen or the Belize citizen, they are debtors. They're not the beneficiaries, they're the debtors. But if let's say, again, going back to a private trust, if you have a private trust and you're authorized to manage the assets of the private trust, and the private trust has rights to the title on that bill, obviously now you're coming in as a creditor from the private side, which means it's a beneficiary. You understand? So I just wanted to expand on that before moving forward. Okay, let me continue reading. If the issuer succeeds in creating a new account, which is an agreement, with the transferee, he might later be able to close that account through a forced payment or collection through a penal action in his administrative proceeding. The issuer has defenses if he issues the instrument for value that he would not have if he had just issued the instrument. He has no authority to issue the instrument, so he has to issue it for value. He is giving a subtle notice by issuing it for value that the transferee has no legal duty to pay or to contract. If the issuer were entitled to enforce the instrument, his instrument would refer to a pre-existing contract in detail. Since the pre-existing contract presumed to support this new simple contract, it is the application for the birth certificate or a pledge of allegiance to the United States, or an application for a social security number, or an application for any number of other benefits granted by the United States. The new instrument must be issued for value. If he issues it referring to a non-existent contract as its basis, he would not have any defenses. He would be acting outside his delegated authority. It appears for value may be translated into to get value or to get consideration. For example, the child acted out for attention. Example, to get attention. The man worked for money. Example, to get money. The issuer issues the instrument for value, to get value. Here's Black Law's definition. Indicate another word for accepting is taking. Acceptance, the taking and receiving of anything in good part, and as it were, a tacit agreement to a preceding act which might have been defeated or avoided if such acceptance had not been made. Black Law's Dictionary. So I guess what they were saying, I guess what this is saying is that you have to bring it back to the original obligation, which was issued for value. So there's already a contract. Again, the contract would be by accepting the U.S. citizen. You accept that you can use the citizen as a surety, but for what? To pay the national debt, right? So that is the contract. Now, if you accept it for value, you send it back, it has to go through that contract that it is to pay the national debt. And I think this helps a lot because at the beginning of my journey, I remember hearing a lot of people, I still hear a lot of people say, oh, they want to cash everything out. They want to get all the money. They want to get all the fiat money. but that's not the contract. It doesn't work that way. So I think that's when we would come as as a U.S. citizen, acting like debtors, wanting to get paper money, you know. Uh, I don't wanting to cash out these bills and get the credit into our account so we can go spend it. You know, that's not the contractual agreement. That's not the initial contractual agreement. Hold on, let me put somebody else on. Okay, let's continue. Acceptance is tricky. No one is required to contract if he doesn't want to, since there is a presumption that every man has previously agreed expressly or tacitly to be a surety for the United States. A naked acceptance appears to recognize that preceding act, whether it actually exists or not. The presumption can be defeated or avoided by not accepting or taking the offer. Not accepting is also tricky. If the presumption of suretyship is allowed to stand unrebutted, non acceptance becomes acceptance. Acceptance puts the liability on the surety. A rebuttal must be through actions, not words. Acceptance for value and return for value is a rebuttal that overcomes the presumption. Refused for cause without dishonor does not overcome the presumption, but it does address defects in the instrument. If an instrument is refused for cause, it must address the right points, or the communication will be seen as a dishonor. It is an option, but it requires more understanding of statutes and rules of court than most people want to learn. In 1966, the Oklahoma Supreme Court explained the importance of applying necessary elements to confirm that an instrument has been taken for value. And it says the first requirement is that the instrument be taken for value. It is clear that the defendant's check were taken by the plaintiff for value. Section 3-303 provides that a holder takes for value when it acquires a security interest in the instrument otherwise than by legal process. In this analysis of the evidence, we have concluded that under the Commercial Code, Supra, in Oklahoma, the plaintiff took the check for value as a matter of law. The jury should have been instructed as to each of these elements and should have been advised that the plaintiff had satisfied the first element of taking for value. Some of the instructions given by the court indicated that taking for value was an issue, and the instructions went further and stated that the bank would be taker for value to the extent it had a security interest in the check. The element of taking for value was very material to the plaintiff's case, People's Bank versus Aurora. So I think that's when it's important. You know, I'm doing my taxes this year, and I noticed that I actually went to the tax department, right? And I said I'd like to report the income, but I also want to report the acquisitions. And the supervisor at the tax department, she was like, "What?" I said, "Well, I want to report the income, but I also want to report the acquisitions of the assets." She's like, "I don't understand what you're saying." She says, "Because you have to report the income and then pay the taxes." I said, yeah, I understand that. I understand that. I'm not saying that, but I'm saying this. I want to report, let's say I report $20 income, right? I got $20. I sold something. Let's say I got $20. But I took that $20 and I went to the gas station, right? Or I went to, anyway, I gave them the $20. And in return, they gave me a receipt. And in that receipt, it shows clearly that a tax was paid on the receipt. The receipt shows that tax was paid and was received. So what I did is I'm going to report the acquisition, meaning that the gas station acquired a security of $20, and within that security, within acquiring that, a tax was paid, and the receipt shows that they got the tax. So it says it right here. I have evidence that they got the tax for that 20 income. So I want to report that so you can go get it from them. So I'm reporting the acquisition of a security, right? And so what I do is that I'm not going to collect it from them. Like, I'm not going to collect it from the gas station personally. I'm going to have tax collectors collect it. So how do I do that? Well, what if I, by consideration, give the tax department the interest? They can go collect the interest, meaning they can go collect tax, and return the asset, return the security or equivalent of that security back to the trust or back to the owner of the asset. So I had a very interesting conversation with them, and she was like, wow, okay, that makes sense. I've never heard of that before. Because here in Belize, they don't have any forms like they have in the U.S. Like the U.S. has the 1099-A, which is an acquisition of secured property, but we don't have that here. But in the codes, in the tax codes, and in the financial orders, it actually says that you can do that you can report purchases. And when you look at the definition of purchase in the Securities Industries Act, it says the acquisition of a security for valuable consideration. It's very interesting. So let me read on. Let me get back to it. Just wanted to share that with you guys. This case was about negotiable instruments. So Article 3 of the Commercial Code controls the meaning of value. The general definition of value in Article 1 does not apply generally to Article 3, negotiable instruments. A negotiable instrument can be a promise, which is a note signed by a maker, or it can be an order, a draft signed by a drawer. The person who is entitled to enforce the instrument is the one who decides if it is a promise or an order, unless its terms require it to be one or the other. This is a personal choice. So UCC 3-104, negotiable instrument. E. An instrument is a note. It is a promise and is a draft if it is an order. If an instrument falls within the definition of both note and draft, a person entitled to enforce the instrument may treat it as either. Okay, hold on. Let me say this again, right? Remember, if we go in as a U.S. citizen or a Belize citizen, all U.S. citizens and Belize citizens, they are debtors, so they can only make promises. They can only make promises. If they have, now I believe that if you're entitled to make orders and promises, and you can take this promise to pay and accept it for value and have the right to utilize it as an asset, and then make an order to pay for setoff. Now you're entitled to both these instruments, but you'd have to come from a different standpoint, not as a U.S. citizen. Obviously, you'd have to come from maybe a private trustee who has the rights to manage the assets of a private trust and trust property. So let's go back. UCC 3-103 definitions. In this chapter, drawer means a person who signs or is identified in a draft as a person ordering payment. Maker means a person who signs or is identified in the note as a person undertaking a pay. Oklahoma court. Let's see. The Oklahoma court referred to the Oklahoma Commercial Code as its source for determining if the checks had been taken for value. As with the general definition of value given at 1-201 of the Commercial Code, it will require close scrutiny to understand the various applications of 3-303. A basic principle of the natural order of things is that the contracts are not valid if consideration is lacking. Before 1933, gold and silver things and promises of performance, which is energy, were consideration. Consideration was and still is anything sufficient to support a simple contract. A simple contract does not have to be written, but it can be. If a contract is written and is not under seal, it is generally a simple contract. A contract under seal, it is not a simple contract. A signature is not required on a simple contract. If you take gold, silver, and things away from the list of what is consideration, the only thing left to be consideration for a modern day contract is a promise. So everything is promise. All the money that we're using is all promises to pay. They're all obligations, right? Let's read on. UCC 3-303 official comment. The distinction between value and consideration in Article 3 is a very fine one. Whether an instrument is taken for value is relevant to the issue of whether a holder is a holder in due course. If an instrument is not issued for consideration, the issuer has a defense to the obligation to pay the instrument. Consideration is defined in subsection B as any consideration sufficient to support a simple contract. The definition for value in section 1-201, which doesn't apply to Article 3, includes any consideration sufficient to support a simple contract. Thus, outside of Article 3, anything that is consideration is also value. A different rule applies in Article 3. Subsection B of section 3-303 states that if an instrument is issued for value, it is also issued for consideration. The official comments say if an instrument is not issued for consideration, the issuer has a defense to the obligation to pay the instrument. The reverse of that statement is if an instrument is issued for consideration, the issuer has no defense to the obligation to pay the instrument. Articles 1, 2, 4, 5, 6, 7, 8, and 9 says value equals consideration. Article 3 says issued for value means issued for consideration. Interesting. The issuer on a demand from the United States is acting as, the issuer on a demand for the United States is acting as an agent of the United States. The issuer on such an instrument is the United States. If the United States issues an instrument for value, the United States has no defense to the obligation to pay the instrument. So the United States has to pay the instrument. If the instrument is issued for value, it says the United States will have to pay the instrument. That only applies, however, if the transferee properly endorses the instrument and returns it to the issuer. The banker for the United States is the Secretary of the Treasury. He or his agent should receive the endorsed and returned instrument. At that point, it is treated like a check and can be deposited to settle an account in a accrual bookkeeping system. Acceptance and acceptance for value are not the same thing. Accepting an instrument without a qualified endorsement waives all defects there may be in the instrument, including the value or lack of value that comes with it. Remember, the official comments for 3-303 says, If an instrument is not issued for consideration, the issuer has a defense to the obligation to pay the instrument. The reverse of that statement is, if an instrument is issued for consideration, the issuer has no defense to the obligation to pay the instrument. If there is no value to support a demand instrument, it has to be issued to get value. A general acceptance of such an instrument successfully transfers the liability the instrument carries to the acceptor. Even if there is no value in the instrument for the acceptor to rely on, the acceptor is still liable. He has no defenses. He must pay it himself. He is going to pay it with a check, or pay it with his prepaid his prepaid account. Oh, is he going to pay it with a check, or is he going to pay it with his prepaid account? If the acceptor can see the value, if the acceptor can see that the value is the commitment of the issuer to pay the instrument, then there is value to the instrument. As long as the instrument is accepted for value. Accepting an instrument for value and returning it is notice to the issuer that the endorser is not providing new value, but is converting the issuer's obligation to pay the instrument into value, thereby making the instrument negotiable. The instrument becomes the payment. Let me read that one more time. Let me read this part one more time. Accepting an instrument for value and returning it is notice to the issuer that the endorser is not providing a new value, but is converting the issuer's obligation to pay the instrument into the value, thereby making the instrument negotiable. The instrument becomes the payment. At the point the instrument is issued for value, it is not a negotiable instrument. At the point the definition of value in Article 1 applies. At that point, the definition of value in Article 1 applies. After it is received by the target, it becomes negotiable. At that point, the definition of value changes to fit Article 3. The instrument, being negotiable, can be enforced by either party depending on what the transferee does with it. If he just holds it or argues about it, the issuer, meaning the United States, is entitled to enforce the instrument. If he, A for V, he is entitled to enforce the instrument. That is a personal choice. So if he does A for V, he's entitled to it. Excuse me. It is better to be a holder in due course of an instrument than the liable party on an instrument. A holder in due course is entitled to enforce the instrument. One can be a holder of an instrument, a hot potato, without being a holder in due course. An instrument issued for value is a hot potato to a holder. A holder has liability. A holder in due course has rights. Remember, rights means remedies, but cannot acquire that position on an instrument issued and transferred for value unless he takes the instrument for value, as said in Article 3-303A2A below, and returns it for value. It is still a hot potato. To be a holder in due course, the holder must meet all the elements listed in 3-302. Okay, let's read this. Okay, subject to the subsection C of this section and section 3-106, subsection D, holder in due course means the holder of an instrument if 1. The instrument, when issued or negotiated to the holder, does not bear such apparent evidence of forgery or alteration, or is not otherwise so irregular or incomplete as to call into question its authenticity. And 2, the holder took the instrument, A, for value, B, in good faith, C, without notice that the instrument is overdue or has been dishonored, or that there is an uncured default with respect to payment of another instrument issued as part of the same series. D, without notice that the instrument contains an unauthorized signature or has been altered. E, without notice of any claim to the instrument described in section 3-306, and F, without notice that any party has a defense or a claim in recoupment described in section 3-305, subsection A. Negotiability. An instrument is not necessarily negotiable when it is issued, and the one who is holding it is not necessarily a holder in due course. All of the 6 requirements listed in 3-302A2 must be met for one to be a holder in due course. The first is that the instrument must be taken for value. According to the Oklahoma case, UCC 3-303 says a holder takes for value when it acquires a security interest in the instrument, otherwise than through a judicial proceeding. Make a note of this. It is a holder who acquires a security interest in the instrument. If he takes the instrument for value, let me say that again, make a note of this. It is the holder who acquires a security instrument in the instrument, who acquires a security interest in the instrument if he takes the instrument for value. It is not the issuer who has the security interest. It is the holder. The issuer has the liability. The holder can waive the security interest with a blank endorsement or accept it with a qualified endorsement. With a qualified endorsement, the holder is accepting the security interest, not the liability. Okay, with a qualified endorsement, the holder is accepting the security interest, not the liability. Judicial court orders can transfer rights and property, creating a security interest in the title to the subject property. But that is not how it works with an instrument that is issued for value. An order for a judicial court created security interest is not the type of instrument that a transferee would take for value. But an order for an executive court created security interest is a type of instrument that a transferee would take for value. United States courts are not judicial courts. They are territorial courts and were created through Article 1, Section 8, Clause 9 by the power granted to the Congress to constitute tribunal inferior to the Supreme Court. Their orders do not result in security interest through judicial proceedings. Okay. A check is negotiated when it is transferred to a payee. It is a note because it is a maker's promise to pay the payee. It is also an order to a third party, so it is a draft signed by a drawer. A named third party, the payer, on a negotiable instrument has a duty to pay it if he is a party to a pre-existing arrangement with the drawer to do so. On a normal check, a bank is the payer. The drawer is the party ordering the payment on the draft. The payee negotiates the check by endorsing it and presenting it to the bank for deposit. If the payee and the drawer bank at the same bank, the bank where the check is deposited can also be the payer. The payee is usually a holder in due course. If the check is lost, a person who finds it is not a holder in due course and is not entitled to enforce the instrument. The one who endorses it takes on the liability if the bank where it is deposited cannot collect on it. He has recourse against the drawer. A check is not an instrument that the payee would take for value, but the bank where it is deposited might take it for value. In the event it believes there may be difficulty in collecting it. If you endorse a check without recourse, you are giving notice that you do not agree to take on the liability. But you may not be able to convince a bank to accept it with that qualified endorsement. If you endorse a check with just your signature and present it to the bank for deposit, you are giving your rights as holder in due course over to the bank. You are also agreeing to take on the liability for the tax on the instrument. That's messed up. An IOU is not negotiable because there is no third party. An IOU is a promise to pay and is signed by a maker. The holder of an IOU can only present it for collection to the maker. Other instruments that are notes, which are promises, are not necessarily negotiable either. United States notes, which are promises, were originally negotiable because the holder could take them to any Federal Reserve Bank, which is a third party, and redeem it for gold or silver. The Federal Reserve notes are obligations of the United States and are not negotiable. They are promises to pay. They are obligations that are not redeemable. See 12 U.S.C. 411 as amended. Federal Reserve notes are considered to be a benefit U.S. citizens get to use within the United States. A promise can be value. Suffering can be value. A benefit can be consideration sufficient to support a simple contract. Using Federal Reserve notes is considered taking advantage of a benefit consideration. In exchange for rights, the United States has to enforce the terms of a pre-existing citizenship contract, which is a pledge. That is the implied basis for its agents to issue bills, instruments to the United States citizens. But they have to be issued for value. The term of that pledge are the hidden basis for issuing instruments for value. There is a default presumption that every U.S. citizen has made a pledge to the United States and its statutes. Other than the issuer's obligation to pay an instrument that is issued for value, there is no value in the instrument when it is issued. It is not negotiable when it is issued. It is seeking a negotiable instrument. An issuer has a defense for issuing instruments without consideration if they're issued for value. And a promise previously made by the transferee, U.S. citizen, is due and has not been performed. The payment on the national debt is always due and has not been performed. If an employee of the United States transfers a bill, which is an instrument, for value to a U.S. citizen, the man who represents him might recognize that the bill has been issued for value, so he can accept it for value and return it for value to close the account on behalf of the U.S. citizen. The U.S. citizen has a legal obligation to pay the bill, and the man has a moral duty to close the account. He can close the account if he first accepts it for value. The bill that was issued for value. He accepts for value the bill that was issued for value. When he does that, he has provided sufficient consideration that is needed to balance the implied consideration that was provided by the issuer. It is like for like. He is actually providing the consideration for both sides of the transaction, i.e., the accrual bookkeeping system. The instrument that is issued for value is the debit side of an accrual account looking for a credit side. Everything is backwards. Usually, you make a deposit, which is credit, to your checking account before you write a check, which is a debit, against the account. You start with the credit, and then you can authorize a debit by writing a check. In the commercial system used by the United States, the debit appears to come first, and you have to supply the credit to make the debit possible. The instrument is the credit, and your endorsement makes it a debit. If you accept that credit for value and return it with a proper endorsement, the instrument balances the account. If you give it a blank endorsement by just holding it, you have to send the issuer another instrument as the credit. To be safe, one who receives an instrument that has been issued for value has to get rid of it as soon as possible. Whoever is holding it is liable for it. It is a hot potato. If the holder fails to recognize that it was issued for value and gives it a blank endorsement, he has become the responsible party replacing the issuer. He becomes the issuer and transferor with the obligation, and the original issuer becomes the transferee. He has to supply the consideration to fund the instrument and close the account. He can do this by writing a check on an open bank account with sufficient funds and sending his check with the bill to the issuer. He can minimize or eliminate that liability by giving the instrument a qualified endorsement, A for V, and giving notice that the one taking the instrument from him has no recourse against him if the instrument ends up being uncollectible. It is uncollectible until he gives it some value. It was issued for value, i.e., to get value, and it does get value when it is properly endorsed. The question is, who is entitled to enforce the instrument? The original transferor or the original transferee? This is a personal choice. Without recourse. Mortgage companies endorse promissory notes issued by borrowers with the words "without recourse paid to the order of ABC Mortgage Company." Above the endorsement signature, they do this above the endorsement signature. That is a qualified endorsement. If ABC can get a third party to accept that paper under the conditions of the endorsement, the third party cannot go to ABC to enforce the instrument. Mortgage companies are almost always affiliated with a bank that will accept this kind of paper. Without recourse gives notice of non-acceptance of liability on the instrument. If the third party ever wants to seize the security supporting the instrument, it must skip ABC and go to the borrower who issued the instrument to ABC, who took the instrument in good faith and transferred it to the third party, who also took it in good faith. The security that backs the instrument stays attached to the instrument. A for V is a qualified endorsement. Adding the words "without recourse" takes you out of the picture as a responsible party. You are not an accommodating party if you use "without recourse" in your endorsement. That's interesting to know. It's very interesting to know. When an instrument is issued for value and accepted for value without recourse and returned for settlement and closure of the account, the third party, which is the Secretary of the Treasury, equals banker, has no recourse against the endorser. One might think that is good, but there is one more thing to consider. The people in the several states formed a society built on service. If you do not want to be a part of that service plan, you can take yourself out of the transaction through the without recourse endorsement. If you want to be of service to the United States and be seen as an ally, it might be good to agree to be responsible to aid and assist the United States in acquiring funds to pay the debt. It is up to you, but be fully informed and know exactly what you want to do. to be before you endorse an instrument that is issued or transferred for value. This is a personal choice. Obligations of endorser subject to subsection B, C, D, and E of this section and to section 3-419, subsection D. If an instrument is dishonored, an endorser is obligated to pay the amount due on the instrument according to the terms of the instrument at the time it was endorsed. Or if the endorser endorsed an incomplete instrument according to its terms when completed, to the extent stated in sections 3-115 and 3-408. The obligation of the endorser is owed to a person entitled to enforce the instrument or to a subsequent endorser who paid the instrument under this section. If an endorsement states that it is made without recourse or otherwise disclaims liability of the endorser is not liable under subsection A of the section of pay the instrument. Instrument signed for accommodation. If the signature of a party to an instrument is accompanied by words indicating unambiguously that the party is guaranteeing collection rather than the payment of the obligation of another party to the instrument, the signer is obliged to pay the amount due on the instrument to a person entitled to enforce the instrument only if execution of judgment against the other party has been returned unsatisfied. 2, the other party is insolvent or is an insolvency proceeding. 3, the other party cannot be served with process, or 4, it is otherwise apparent that payment cannot be obtained from the other party. An accommodation party, which is a United States citizen who accepts an instrument that is issued and transferred for value, is presumed to guarantee collection as well as payment for the obligation of another party in the instrument to the instrument. The accommodation party is only obligated to pay the instrument if one of the 4 criteria is met. One of them is that the other party, the one obligated to the instrument on the instrument, which is the United States, is insolvent or is an insolvency proceeding. The issuer usually has the obligation to pay the instrument, since he would be paying himself if the instrument is issued and transferred for value, and then accepted for value and returned for value. The certainty of the transaction results in a debit and a credit. That makes for a balanced account. Without the transferee's blank endorsement, the project does not work. Liability is not transferred. The issuer of an instrument that is issued for value has defenses, but if it is A for V and returned for value, the issuer has no defenses. The issuer does not need defenses if he closes the account, but if he does not want to give it up, he could issue a second instrument for the value to see if the endorser on the first one might change his mind and agree to take liability for the second one. The instrument issued for value could be a tax bill, or a complaint, or a penal action, which is an indictment, on which the United States is the issuer and the liable party. Issued or transferred for value, UCC 3-303. Under the definition of value in 1-201-44, a person gives value for rights if he acquires rights through several means listed in the subsections. A person gives value in return for any consideration sufficient to support a simple contract under Article 3, dealing with negotiable instruments. And an issuer does not have to give value if he issues an instrument for value. UCC 3-303 official comment says, thus, outside Article 3, anything that is consideration is also value. A different rule applies in Article 3. Subsection B of Section 3-303 states that if an instrument is issued for value, it is also issued for consideration. Okay, so wait a minute. So there are two ways, according to what they're saying, things can be issued, right? One can be issued just like that, or it could be issued for value. If it is issued for value, obviously, it says here that it falls under UCC 3, under negotiable instruments. But if it's just issued, it's not under Article 3. Okay, so UCC 3-303, value and consideration. An instrument is issued or transferred for value if. Okay, so this is how we're going to know if it's transferred for value. The instrument is issued or transferred for a promise of performance to the extent that the promise has been performed. The transferee acquires a security interest or other lien in the instrument other than a lien obtained by judicial proceeding. 3, the instrument is issued or transferred as payment of or as security for an antecedent claim against any person, whether or not the claim is due. 4, the instrument is issued or transferred in exchange for a negotiable instrument. Or 5, the instrument is issued or transferred in exchange for the incurring of an irrevocable obligation to a third party by the person taking the instrument. B, consideration means any consideration sufficient to support a simple contract. The drawer or maker of an instrument has a defense if the instrument is issued without consideration. If an instrument is issued for a promise of performance, the issuer has a defense to the extent performance of the promise is due and the promise has not been performed. If an instrument is issued for value, as stated in subsection A, the instrument is also issued for consideration. This section explains how an instrument is issued for value and transferred for value. There is no comma before the or, so or can mean and or. The issuer is the party who is liable on an instrument until he can transfer his liability to another party. Let's see if there's anybody. Oh yeah, we have somebody. I gotta put someone in. It's Ernesto. Give me 1 minute. Welcome, Ernesto. Let me go back to this. So this, as you can see, this document clearly, as further we go along, it ends up explaining a little bit more. It expands a little bit more, and you can see that the whole topic of acceptance for value, it is not as simple as we think it is, and it is because that there was a change in the banking system. Before, it was gold, silver, and things, right, could be used as consideration. Now it's just a promise that is needed. An obligation is consideration, is value. So if we have rights to an instrument and conveyed the rights, which is the interest, to the issuer, now what we have done is we've given value, or we've given consideration. So now the issuer has no defenses. You understand? They now become liable because they've received the value, they've received the consideration. That's just by giving interest, right? So let's continue. UCC 3-105, issue of instrument. A, issue means the first delivery of an instrument by the maker on a note or promise, or drawer on a draft order, whether to a holder or non-holder, for the purpose of giving rights on the instrument to any person. And again, when you hear rights, just try to remember that you can supplement that, or you can use remedies. Rights, remedies, they're interchangeable in commerce. The issuer of an instrument intends to give rights on the instrument to another person. That other person might be you if you endorse it properly. UCC 3-303 explains how the person you represent in commerce in the United States can start out being a target and end up being the one entitled to enforce the instrument. UCC 3-103 definitions in this chapter. Drawer means a person who signs or is identified in a draft as a person ordering payment. Maker means a person who signs or is identified in the note as a person undertaking to pay. Remember, undertaking is the one taking on the liabilities, the one saying, yeah, I'm gonna pay for that. It's an obligation. Undertaking creates an obligation. So an instrument can be issued and transferred for value to a holder by a drawer if it is an order, or by a maker if it is a promise. The transferee has to decide if the instrument is an order or a promise. If he understands his options, it would be better for him to make the instrument a promise. Oh, nice. Then the issuer has an obligation to pay. The currency of the United States is based on promises, which are agreements. United States courts enforce agreements. Both parties can proceed on the basis of a simple contract. A simple contract does not have to be written and does not require a signature. A transferee's signature will be presumed if it is not actually given. If you want to contract with someone, you can send him an offer to contract to see if he wants to contract with you and if he accepts your terms. If he does not want to contract, he can return your offer and decline to contract. That is called non-assumptive, or I do not undertake. Assumptive is an implied agreement to contract, thus a simple contract. If he does want to contract with you, but not on the terms you proposed, he can return the contract with different terms for your signature. You can terminate the negotiation by non-assumptive. Sorry, I'm having a hard time saying this word. Assumpsit. At the point or purpose different terms and return the contract for his signature. If one party decides to terminate the negotiations, he just returns the contract with no signature. That is the scenario if the parties do not already have an obligation to contract. If the transferee has an obligation based on a pre-existing contract, signed or not, he has a duty to respond and may have a duty to respond in a certain way. The lowest position is the one who has a duty to pay because of a pre-existing agreement. See, this pre-existing agreement thing right here, it leads me again to okay, let's go back to let's say a utility bill, right? When we opened the utility account, there is a customer agreement, right? And we don't have to sign that customer agreement most of the time. Sometimes we do, sometimes we don't, depending. Even with certain banks, I've read certain the customer agreement with the banks, and it actually does say, in those agreements that any transfer of instruments or any instruments received by them will be considered waived unless specifically written or given notice to them that it is not waived. And again, waived means abandoned. So anything we give to them, according to the customer agreement, is considered abandoned off the back, unless we mention something about it, unless we state or we give notice, right? So again, that's going back to the pre-existing agreement. We got to go back to that, and I think that's when we have to give a notice and bring back up the agreement and say, hey, you know what, I read the agreement, and from now on, I'd like to make it perfectly clear that the instruments that is being sent is not being waived. The securities are not being abandoned. When I send you the security, I need these are the instructions that I would want you to follow in regards to these instruments that is being conveyed to you as an asset. Okay, so let's see. Let's get back to it. Through citizenship, you are presumed to be in that position as a surety for the United States on the national debt through a presumed promise of performance on a simple contract. A tax bill can be an instrument issued for value and delivered with the intent of transferring the liability of the national debt to the transferee. A civil complaint and a penal action, which is an indictment, are also instruments that can be handled the same way. They are looking for someone to accept liability. The following explains the first subsection of UCC 303-303. Value and consideration. An instrument is issued or transferred for value if the instrument is issued or transferred for a promise of performance to the extent the promise had been performed. B, if an instrument is issued for a promise of performance to a United States citizen, the issuer, the United States, has a defense to the extent performance of the promise is due and the promise has not been performed. If an instrument is issued for value as stated in subsection A, the instrument is also issued for consideration. Subsection B says the issuer has a defense if he issues an instrument for value and the promise is due and not has been performed. But if he issues it for value and the promise has not been performed because it is not due, he has no defense. If he issues an instrument and there is no promise, he has no defense. If a stranger is sent an instrument that is issued for value and he does not pay it, he is not in default because he has no duty to pay it. If a surety is sent an instrument that is issued for value and he does not pay it, he is in default and is in breach of his agreement to the surety, to be surety. If performance is due and has not been performed, the agent issuing and transferring the instrument for value has a right to pursue collection. If you are presumed to be a surety for the United States through the U.S. citizenship, and if an agent for the United States sends you a bill, what are your options? If you act like a surety, you have to pay it. If you do not think you are a surety, you can refuse it for cause. But if you have done things in the past that makes you look like you're a surety, refusal for cause is not the best option. If you are a stranger and you pretend to be a surety and pay the instrument using a security, You have just registered with a fiduciary in the United States. You are not in default. 3-303 says an instrument is issued or transferred for value if the instrument is issued or transferred for a promise or performance, to the extent the promise has been performed. It sounds like the instrument is a receipt for performance of a promise that has already been done. Why would one argue about receiving a receipt? This is a bifurcated statement. The first part says the instrument is issued for value, i.e., to get value. The value being sought is a new promise of performance. The second part of the statement admits a promise has already been performed. Under the fiction that you have previously set up the person you represent as a surety, the United States is putting the best construction on the instrument. The issuer is assuming the promise of suretyship that has already been made will be performed on this new request. Now it is time to put up or shut up. The principle of suretyship is not difficult to understand. Being a surety is not a one-way street like being an accommodation party. The accommodating party lends his name on his credit to another person, but gets nothing in return. One who agrees to be a surety for another party would receive an asset from the one asking the surety for the service. For example, an officer may need 2 sureties before he can commence his official duties. He would find 2 people who agree to be his sureties. They would sign a document, perhaps a bond, as sureties for the officer. The officer would give the sureties an asset, like a deed of trust, as a security for them in the event they would be required at some time to pay a debt for the officer. If the officer were a tax collector and he died, all of his accounts would have to be settled. If there were no money in his accounts to pay over the taxes he had collected, his personal property would be used to settle that debt. The United States and its creditors do not want to spend the time or money to liquidate the dead officer's personal property, so they just go to the sureties to collect. The sureties are required to pay immediately. Then the sureties, as holder in due course of the deed of trust, have the right to enforce the deed. They can sell the real property connected to the deed of trust so they can be reimbursed. The dead officer's heirs cannot claim a right to that property because the deed of trust the sureties hold is an enforceable instrument. That's interesting. That's super interesting. Hold on, let me see. There's somebody here. I got to put in 1 minute. Excuse me. Sureties for the United States have the same options. Since the sureties are fictions, the people who represent those sureties can opt to use their prepaid account to pay when they receive instruments that are issued and transferred to them for value. They do not have to pay with their public deeds, accounts, and cash of the persons they represent. If they do pay with public currency, they have the right to be reimbursed. If they opt to use their prepaid account, they use the Secretary of the Treasury to set off the debt. Either way, the surety stays in honor and performs according to his promise. You have to make a choice. No action is a choice to be a surety and to pay with the public deeds, accounts, or cash. Do you want to try to prove you are not a U.S. citizen and a surety for the debt of the United States, the debt the United States owes the creditors? I am not that person is a defense many people have tried to use in the past with little success. That is true. Let me see here. Do you want to try to prove, as a presumed U.S. citizen and surety for the national debt, that you don't have to pay the instrument? Would it be easier to help them close that account? Suretyship is a fiction. It is based on an implied promise. If you were born on the land in Montana, you are one of the beneficiaries on the trust created by the Constitution and President Roosevelt. Do you want to try to prove that in one of their penal do you want to try to prove that in one of their penal action courts? That might be too much truth for a fiction court to deal with. That is also a defense that has been tried with little success. The obligation the United States owes to you is based on a promise that is better than an implied promise. You have a certified copy of a security that acknowledges the obligations of the United States owed to you. It is evidence. It evidences a promise, even though the terms are implied and are not actually expressed on the face of the birth certificate. Would it be easier to use one implied promise to set off another implied promise? If you accept their offer for value and return it for value, at least you have not given them an implied general acceptance of liability. If you are going to accept their offer, would it be better to do it on your terms? Fighting with them has not resulted in much success in the past. Is it possible it will be easier to close the account by going along with their implied contract, which is a promise, bringing in another implied contract, promise, and letting them use you to close their books? This is a personal choice. The second subsection of 3-303 deals with a security interest that is inherent in every instrument that is issued and transferred for value. UCC 3-303 value and consideration. An instrument is issued or transferred for value if the transferee acquires a security interest or other lien in the instrument other than a lien obtained by judicial proceeding. Now, this one's an interesting one. Let's listen. Let's read on. The transferee is the person to whom the instrument is delivered. It is the transferee who has the option of acquiring a security interest in the instrument that was delivered to him. 100 years ago, if a man borrowed $200 from a bank, he would receive $200 of silver or its equivalent in bank notes. That would be the bank's consideration. The man would sign a note and give it to the bank. That would be the man's consideration. The bank acquired a security interest in a thing, maybe the man's farm, through not through judicial proceeding, but through the intentional action of the man. If the man did not repay the $200, his note would be evidence of the promise that he had breached. The bank could send the man a demand for payment. The demand for payment would not be an instrument issued for value because the bank actually had the man's written and intentional promise. The man did not acquire a security interest in the demand instrument from the bank. The man could not accept the demand for value and return it for value to settle the account. That's true. That's true. Now, in today's commercial system, when Mr. Taxman, an agent of the United States, sends a U.S. citizen a demand for payment, he does not have a man's intentional written promise to pay. He has to issue the instrument for value. and the transferee automatically acquires a security instrument in interest in the instrument. This security instrument is not obtained by judicial proceeding. Assuming the transferee accepts the instrument and does not pay it, the United States becomes the transferee and acquires a security instrument in acquires a security interest in the instrument. The positions switch. It is assumed the transferee has given it a blank endorsement via his unqualified acceptance, his silence, and then issued the instrument back to the United States. The new issuer is obligated to pay the instrument. If he had recognized the instrument as one that was issued for value, he would have known he had to A for V and return it for value to give notice he intended to enforce his security interest on that instrument. Even when the United States gets a judgment in its favor from the United States court, it does not acquire a security interest through judicial proceeding. United States courts are executive courts and have no authority to issue judicial orders. Wow. If an appeal on an administrative order based on an instrument that had been issued for a value and A for V were properly brought in an actual judicial court, the judicial court would have to rule in favor of the petitioner, but that will never happen. There are administrative procedures to settle these cases before they get to the judicial court. Some CID offices are appeal offices, and the officers who work there have the authority to investigate the facts of a commercial settlement and actually do the accrual, bookkeeping, and close the accounts. If the appeals office does not close the account, or if it closes the account but does not give notice to the parties and the public, there is a higher office that can handle an appeal from an appeals office actions or inaction. Every agency of the United States has an inspector general who has a duty to detect and prevent fraud, waste, and abuse. If the facts of your settlement gets to his office, his position as a direct appointee of the president requires him to assure there is no fraud, no waste, no abuse. This is from the book 39 IRS Arguments That Don't Work and Why explains Inspector General functions in more details. It can be found on lulu.com. A corporation issuing a stock certificate, a bond, or other security is obligated to pay the instrument. The corporation, which is the issuer, is liable to pay according to the terms of the certificate bonds, the certificate or the bond or other security, which are instruments that might be negotiable, or they might be non-negotiable at the time they were issued. If an instrument is intended to be negotiable, a third party must enter the process. A promissory note for a mortgage is issued by a borrower who is the maker. It appears to be a two-party instrument, like an IOU. The maker usually does not expect his note to be negotiated, but it is. He is making a promise and giving the legal description of the land he is buying as security for his promise. He necessarily must already have an interest in the legal description through the purchase agreement for him to be able to pledge that legal description on the deed of trust as security for his promissory note. The deed of trust is an unnecessary component of the loan process because the promissory note is sufficient to fund the loan. The promissory note is given by the borrower to the lender, which becomes the transferee and acquires a security interest in the note and the, in the legal description pledged as security. The lender is not obtaining a security interest through a judicial proceeding. It acquires the security interest in the instrument through voluntary transfer by the borrower. The security interest is the value. The promise is value. The subsequent payments are value. The subsequent seizure of the property in foreclosure is value. The borrower is supplying all the value. The maker on the promissory note is expecting to receive value from the lender, and the lender is expecting to receive rights in the property being pledged as security for the loan. The lender negotiates the note and transfers its rights and obligations in the note to a bank, which is a third party, that takes the note for value along with the rights in the security. The definition of value in Article 1 of use of the UCC used that process as one of the examples of value. UCC 1-201, a person gives value for rights if he acquires them. A security for or in total or partial satisfaction of a pre-existing claim. Both parties to an instrument. Hold on, let me put somebody in. There's somebody who needs to come in. Hold on. Okay. All right. Oh, he got kicked out again. Okay, here we go. He's back. Okay, let me go read. Both parties to an instrument give value and get rights. A lender gives value to the borrower in the form of banking services. In exchange for rights, the lender receives in the promissory note. The borrower gives value to the lender in the form of the man's signature, in exchange for rights to use currency in the public. The birth certificate is an instrument that gives value in exchange for rights. It is also an instrument that is issued based on value received and represents rights that are given back in exchange. Rights in the birth certificate as a security are only available to the man on the public side, but he needs a fiduciary on the public side to hold the security for him. The man cannot use the birth certificate on the public side. He is substance, and the public side is fiction. He cannot go there. The birth certificate is an instrument that is seen from two different perspectives. From the public side, the birth certificate is a security interest in the labor of the United States citizen the certificate represents, based on the United States citizen's pledge to the United States. Now, from the private side, the birth certificate is a security interest in distributions from the trust established by the Constitution and by President Roosevelt in 1933. On the public side, the United States has an antecedent claim against the U.S. citizen's labor through the pre-existing contract pledge. On the private side, the man has an antecedent claim against the United States through the pre-existing contract, which is the Constitution and the Article 6 and Article 2 oaths. Mortgage notes disclose the existence of an antecedent claim with the words, "For a loan I have received," in the first line of the borrower's written promise. The borrower has not received a loan at that point, but nonetheless, he is promising to pay on some pre existing loan, which is the national debt, on every mortgage note he signs. A man gives value through his signature on a note in exchange for rights to future set off. He acquires his right to future set off as security for or in partial satisfaction of a pre existing claim he has through his position as beneficiary on the trust created by the Constitution and President Roosevelt. It is this beneficiary position that you are using when you accept for value. There is no value in an instrument that is issued for value when it is issued. It is issued to get value. An instruments that are used, sorry, instruments that are issued for value is very different than the kind of instruments you sign as a borrower. You are providing value in your instrument at least twice. You are giving the other party a written promise to pay and putting up a security, legal description, and you are admitting you have already received the loan. In an instrument that is issued for value by the United States, there is no express promise to pay you, and there is no security given to you when you receive it. The only way you can make that instrument payable to you is to accept for value. So you can enforce your security instrument in that instrument. Sorry, you can enforce your security interest in that instrument. When an instrument is issued by an agent of the United States based only on an implied promise, it has to be issued for value, or the issuer would have no defenses against a claim of fraud or abuse. If the transferee has a security interest in the instrument, if the issuer cannot produce an antecedent claim based on the pre existing contract, which the issuer cannot do. Let me read that one more time. The transferee has a security interest in the instrument if the issuer cannot produce an antecedent claim based on a pre existing contract, which the issuer cannot do. If he could, it would not be issued for value. Now, if the instrument is not accepted for value and then returned for value, the transferee waives his security interest in the instrument and waives his position as holder in due course with the right to enforce the instrument. The issuer has the liability until someone else takes on the liability. That is supposed to be the transferee if the agent's plan works. Transfer means moving something by a transferor to a transferee from one place to another. In commerce, a transferor is usually attempting to transfer his liability to the transferee, which is fine if he is also transferring the security interest along with the liability. In the United States, it is presumed the transferee, the United States citizen, has an obligation on the pre-existing contract, which is a pledge, to pay an instrument as the result of another party, which is the international bankers, having a direct or indirect antecedent claim against the transferee. It could even be a pre-existing claim against the transferee's United States citizen creditor, United States. This is where public and private become hazy. When the United States is dealing with its sureties, which are the US citizens, you are looking at the public relationship controlled by public policy. The people are not under public policy. France is not under public policy of the United States either. When the federal United States is dealing with the country of France, the relationship is governed by the laws of nature. It is a private agreement. When corporate United States is dealing with corporate France, the relationship is governed by law merchant. That is also by private agreement, but under a different set of rules. When the United States is dealing with its creditor, you're looking at a private relationship between corporate United States and other corporate persons that supposedly made loans to corporate United States. The law merchant governs commercial actions among corporate nations. It is public law, but the law of the individual contract corporate United States has with those other corporate persons is private law. When the national United States is dealing with its corporate subdivisions, state of California, state of Indiana, that relationship is governed by public law. The law of the contracts corporate United States has with its corporate subdivisions is administered by public policy. The law of the relationship the national United States has with its officers, agents, and employees is controlled by public law through statutes. The law of the relationship between the federal government and the people in the several states is the Constitution. This is a private agreement. The people cannot have public contracts with corporate United States. They already have a private agreement that puts the people as beneficiaries and the president as the executive trustee. These are all relationships that are governed by some kind of law, often a law that is not even considered by one of the parties. Says people with people, that's private law as agreements, several states with people is private law, state constitutions, federal United States with people, that's private law, Article 6 oaths, United States citizens with people, those are private laws, private agreements, corporate United States with the people, those are private laws and agreements, international lenders and people, there's no relationship, federal United States and several states like Ohio, those are private law, those are constitution. Federal United States and other countries, those are private laws, those are treaties. Corporate United States with international lenders, that's private law, those are agreements. Federal United States with foreigners, those are private laws, those are laws of nature and nature's God. National United States with US citizen, that's public law, statutes. National United States with its member states, state of Ohio, that's public law. Corporate United States and other nations, that's public law and international law merchant. National United States, foreigners, that's public law, international law merchant. Technically, the United States has no obligation to the international bankers. Technically, a United States citizen has no direct obligation to the international bankers, so their presumed claim against the U.S. citizen is initially a failure. If the United States can get its surety, the U.S. citizen, to acknowledge the claim being made by the international creditors through the process of novation, the objective can be accomplished. The objective being that the United States citizen has voluntarily taken on the liability of the national debt. That is going to be in the capacity of one, an accommodation party, or two, a surety. Sureties have rights, accommodating parties don't. That would be a political election, and only the person can take that choice. Since you are representing a U.S. citizen, it is your choice. When the transferee receives an instrument issued by the transferor, when the transferee receives an instrument issued and transferred for value, he has options. He can, one, accept it and pay it, two, refuse it for cause and return it, or three, accept it for value and return it as payment. the transferee gets an implied security interest, which is consideration, that he can enforce against the security the issuer is supposed to be passing on to the transferee. By operation of law, the instrument must carry the issuer's obligation to pay. UCC 3-303, official comment. If an instrument is not issued for consideration, the issuer has a defense to the obligation to pay the instrument. UCC 3-303. Hold on, let me put some. There's some people that need to come in. 1 minute. There you go. All right. Thus, outside Article 3, anything that is consideration is also value. A different rule applies in Article 3. Subsection B of Section 3-303 states that if an instrument is issued for value, it is also issued for consideration. So to avoid fraud, the instrument has to be issued for value. It gives the transferee, the U.S. citizen, a security interest in the instrument. Okay, so hold on. Let's pause it right here. Hold on. So going back to the birth certificate, right? Says that when we receive that, it is like a receipt because it is evidence that there is an obligation due to the one who's entitled to the birth certificate. So we get the birth certificate, right? We now hold in our hand evidence of an obligation due to the, you could say, the owner of this birth certificate or the security, right? So there is an interest implied in that security, in that birth certificate. There's already an interest there. So now we have the right now to use that interest, give it back to them as consideration to set off certain accounts, right? So hopefully that makes sense. Let's go back to this. Okay.
Like a transfer.
What's that?
I said like a transfer.
Okay.
You transfer it.
Yeah. So like an assignment or a transfer or like supposedly a payment, when we get an instrument and we want to pay it off, it seems that we can pay it with the interest, but we have to accept it for value because it's implied in that instrument that there is an interest in that. So when we accept it for the value, we're accepting that there is an interest in that. So now when we give it back or we convey it back, so we have to convey it also with that interest. So we got to give them that interest. So that interest could be value and considerations. Now they have no defense. Now they have to perform. So that makes sense. That's why there is no value, right? And there's no gold and silver. So the thing that we can use for payment, according to this, is the interest. That's the consideration.
Got it.
Okay, so let's see. To avoid fraud, the instrument has to be issued for value. So I would assume that's what they're doing. When they issue it, they have to give it for value, right? To avoid fraud. But it's implied. It's not always going to be in our face. It's implied. So I would say that is why every income has some tax attached to it, because that tax is actually the interest. Understand? But because we don't accept it for value, it goes back to them, then they have now the rights to, and then it gets switched. Now they have the rights to collect it, but as tax. You know? So anyway, let's go back to it.
Got it.
Um, it gives the transferee, a U.S. citizen, a security instrument interest in the instrument. The only piece of paper a man has the proof, sorry, the only piece of paper a man has that is proof of the security interest he has is the birth certificate. He has no value on the other side, but it does on the private side. Sorry, but it does on the public side if he deposits with an appropriate banker who can then be the man's securities intermediary, and the man can be the entitlement holder. This is explained in UCC Article 8 in the 500 series. The following insert is taken from Wikipedia, an online dictionary. Okay, operation of law. The phrase by operation of law is a legal term that indicates that a right or liability has been created for a party, irrespective of the intent of that party, because it is dictated by existing legal practice principles. Events that occur by operations of law do so because courts have determined over time that the rights thus created or transferred represent what the intent of the party would have been had they thought about the situation in advance, or because the results fulfilled the settled expectations of parties with respect to their property, or because legal instruments of title provide for these transfers to occur automatically in certain named contingencies. Rights that arise by operations of law often arise by design of certain contingencies set forth in a legal instrument. Rights or liabilities created by operation of law can also be created involuntarily because a contingency occurs from which a party has failed to plan, example, failed to write a will, or because a specific condition exists for a set period of time, example, an adverse possession of property, or creation of an easement, failure of a court to rule on a motion within a certain period automatically defeating the motion, failure of a party to act on a file complaint within a certain time causing dismissal of the case, or because an existing legal relationship is invalidated, but the parties to that relationship still require a mechanism to distribute their rights. Example, under the Uniform Commercial Code, where a contract for which both parties have performed partially is voided. The court will create a new contract based on the performance that has actually been rendered in the and containing reasonable terms to accommodate the expectations of the parties. Because title to property that arises by operations of law is usually contingent upon proof of certain contingencies, the title records may not contain evidence of those contingencies. Legal proceedings are sometimes required to turn title that arises by operation of law into marketable titles. Your order that the birth certificate be deposited by a securities intermediary makes it a security. It appears that the birth certificate is not an actual security until it passes to a second holder, i.e., from the issuer, which is the state of, to the Department of Commerce of the United States. The United States uses the certificate until you decide you want to use it. You have the priority right to it as a security for the obligation of the United States has to you. it was issued to you. UCC 8-102A15, security, except as otherwise provided in Section 8-103, means an obligation of an issuer or a share, participation, or other interest in an issuer or in property or in enterprise of an issuer. So, hold on, let me read that one more time. This is important to understand. Security, except as otherwise provided in Section 8-103. This is what it means. Means an obligation of an issuer. So the United States is the issuer, right? Or a share or participation or other interest in an issuer or in property or an enterprise of an issuer. One, which is represented by a security certificate in bearer or registered form, or the transfer of which may be registered upon books maintained for that purpose by or on behalf of the issuer. Two, which is issued of a class or series or by its terms, is divisible into a class or series of shares, participation, interest, or obligations. And three, which is or is a type of dealt in or traded on securities exchange or securities market. Or B, is a medium for investment and by its terms expressly provides that it is a security governed by this article. So this basically just explain what birth certificate is. Basically, because who is the issuer? The issuer is at the top. It says it right there, right? The government. And so it is basically like a share of that entity. So it has an obligation to perform. So depositing the birth certificate, which is a security, makes the Secretary of the Treasury a securities intermediary. UCC 8-102A14 says a securities intermediary means a clearing corporation. Two, a person, including a bank or a broker, that in the ordinary course of its business maintains securities accounts for others and is acting in that capacity. He is holding something of value, a financial asset, which is a birth certificate, which is a security, in a securities account for you. UCC 8-501, securities account. This is what a securities account means. Let's read. So, hold on, let me put somebody in. Sameka, she came out. I think people get kicked out by accident or something. Who knows? Okay, there you go. Securities account means an account to which a financial asset is or may be credited in accordance with an agreement under which the person maintaining the account undertakes to treat the person for whom the account is maintained as entitled to exercise the rights that comprise the financial asset. B, except as otherwise provided in subsection D and E, a person acquires a security entitlement if a securities intermediary, 1, indicates by book entry that a financial asset has been credited to the person's securities account. 2, receives a financial asset from the person or acquires a financial asset from the person, and in either case accepts it for credit to the person's securities account. Or 3, becomes obligated under other law, regulation, or rule to credit a financial asset to the person's securities account. So obviously, if we send the birth certificate to the treasurer, the treasurer deals with securities, right? And they receive it, they accept it. Now they are holding an asset, right? They've received a financial asset from some person, and they've acquired that financial asset from certain person, right? So they accepted. Now what exists is a securities account. Very, very interesting stuff. Very, very interesting. His acceptance of your financial asset makes you an entitlement holder with a securities entitlement. UCC 8-102A9, financial asset. Except as otherwise provided in Section 8-103 means a security. Financial asset is also an obligation of a person, or it's a share or a participation or other interest in a person, or interest in a property, or interest in an enterprise of a person, which is or is of a type dealt in or traded on financial markets, or which is recognized in any area in which it is issued or dealt in as a medium of investment. Or three, a financial asset is any property that is held by a securities intermediary for another person in a securities account if the securities intermediary has expressly agreed with the other person that the property is to be treated as a financial asset under this article. UCC 8-102A17, security entitlement. What is security entitlement? So, security entitlement means the rights and the property interest of an entitlement holder with respect to a financial asset specified in Part 3. UCC 8-102A7, entitlement holder. What is an entitlement holder? It means a person identified in the records of a securities intermediary as the person having a security entitlement against the securities intermediary. Official comment. Because many of the rules in Part 5 impose duties on securities intermediaries in favor of entitlement holders, the definition of entitlement holder is, in most cases, limited to the person specifically designated as such on the records of the intermediary. The last sentence of the definition covers the relatively unusual cases where a person may acquire a security entitlement under Section 8-105. It says here, even though the person may not be specifically designated as an entitlement holder on the records of the securities intermediary. So you can give him another bond written against the security. Bond equals birth certificate he's holding. A promissory note can be written against the bond that is written against the security. Such a promissory note would be an order from the entitlement holder to the securities intermediary to use the security he is maintaining for a specific purpose. So it means that promissory note is issued, that's the obligation, and what secures the obligation is the security, which is the birth certificate. That secures the obligation. So you have the obligation, but you have something which secures the obligation. Why? Because the security, the birth certificate, represents the interest that is owed to you or to the owner of the security. So that makes sense. UCC 8-102A8, entitlement order. What's an entitlement order? It means a notification communicated to a securities intermediary directing transfer or redemption of a financial asset to which the entitlement holder has a security entitlement. UCC 8-505, duty of securities intermediary with respect to payments and distributions. A securities intermediary shall take action to obtain a payment or distribution made by the issuer of a financial asset. A security intermediary satisfies the duty if The securities intermediary acts with respect to the duty as agreed upon by the entitlement holder and the securities intermediary, or in the absence of agreement, the securities intermediary exercises due care in accordance with reasonable commercial standards to attempt to obtain the payment or distribution. B, a securities intermediary is obligated to its entitlement holder for a payment or distribution made by the issuer of a financial asset if the payment or distribution is received by the securities intermediary. Since securities intermediaries have obligations to entitlement holders, the securities intermediaries must have capacity to act. That is done under the premise that a securities intermediary is declared in the commercial code to be a purchaser for value. The indirect holding system of the United States would not function as expected if the securities intermediary did not have the capacity to act. Without the rights of an owner or a purchaser, the securities intermediary would be powerless to act in the intended manner. Securities intermediary as purchaser for value. This is UCC 8-116. A securities intermediary that receives a financial asset and establishes a security entitlement to the financial asset in favor of an entitlement holder is a purchaser for value of the financial asset. Official comment. This section is intended to make explicit 2 points that which implicit in order. Wait, hold on. Let me read this again. Hold on. This section is intended to make explicit 2 points that which implicit in other provisions are of sufficient importance to the operation of the indirect holding system that they warrant explicit statements. Firstly, it makes clear that a securities intermediary that receives a financial asset and establishes a security entitlement in respect thereof in favor of an entitlement holder is a purchaser of the financial asset that the securities intermediary received. Secondly, it makes clear that by establishing a security entitlement in favor of an entitlement holder, a securities intermediary gives value for any corresponding financial asset that the securities intermediary receives or acquires from another party, whether the intermediary holds directly or indirectly. In many cases, a securities intermediary that receives a financial asset would also be transferring value to the person from who the financial asset was received. That, however, is not always the case. Payment may occur through a different system than settlement of the security side of the transaction, or the securities might be transferred without a corresponding payment, as when a person moves an account from one securities intermediary to another. Even though the securities intermediary does not give value to the transferor, it does give value by incurring obligations to its own entitlement holder. Although the general definition of value in section 1-20144D should be interpreted to cover the point, this section is included to make this point explicit. Okay. William needs to be put in. Hold on 1 minute. All right. If the transferee actually is a party to a pre-existing contract, he must pay it or refuse it for cause due to some defect in the collection process. Even if he is presumed to be a party of a pre-existing contract, he has the option of renegotiating the terms of that contract or introducing a new contract. I believe that's called a conditional acceptance. If he just accepts the instrument and does not timely, one, pay it, or two, refuse it for cause and return it, he is in default. The reason he can refuse it for cause and return it might be that there is some doubt as to whether the transferee is actually liable for an antecedent claim on the pre existing contract. There is also some doubt that the proper procedures were used to transfer the debt. Wait, hold on. There is also some doubt that the proper procedures were used to transfer the debt to the transferee. Options. Uh, what is that? One acquires the transferee to part his possessions. Hold on, let me read that again. This is weird. What is that? Option one requires the transferee to part with possessions, such as cash, digits in a bank account, or titles to things. Option two requires the transferee to understand a great deal about court procedures and the ability to think on his feet if he participates in a court proceeding. Option two is very useful to those who have learned the mechanics of the administrative courts. It is also useful if the transferee starts an immediate dialogue with the issuer as soon as the instrument is delivered. The focus for this option must be on due process. It cannot present arguments about the existence of the obligation or the amount of the obligation, but can present questions about proper collection procedures. Option three requires knowledge of who you are and how to enforce your rights. Hmm. If the instrument is issued for value, it can be accepted for value because it comes with a security interest built into the instrument. If the transferee accepts the instrument for value and returns it for value, he is acknowledging the instrument was issued for value. He is informing the issuer that he intends to renegotiate the terms of the implied simple contract, that he is a surety, or introduce terms for a new contract. On a new contract, the issuer can be made to acknowledge that he is liable for the instrument he issued. If the issuer has defenses, he will be okay. If the issuer's defenses normally would be on the record of an antecedent claim on the pre-existing contract, but he might have to produce it. Since it is a simple contract, it will be difficult to produce. The evidence of that simple contract is signed applications for the birth certificate, for the social security number, for the licenses, for the passports, for the permits, for the bank accounts, etc. These are all evidences of a simple contract. If the pre-existing claim resulted from an implied contract that the transferee is a surety, the issuer will not want to produce it. If the United States issues and transfers an instrument for value, it runs the risk of having it returned for value, putting the liability back on the United States, which has no choice but to close the account. It has no actual antecedent claim based on a pre-existing contract. So you hear that? So let me read this one more time. Listen to what it says. If the United States issues and transfers an instrument for value, it runs the risk of having it returned for value, putting the liability back on the United States, which has no choice but to close the account It has no actual antecedent claim based on a pre-existing contract. The issuance of an instrument with nothing to base it on normally would be a violation of commercial principles and would be fraud. But under Article 3, an instrument can be issued for value to avoid the normal penalty for fraud. It is the transferee's choice as to how it will all turn out. So again, hold on, let's read this. So it says the issuance of an instrument with nothing to base it on normally would be a violation of commercial principles and would be fraud under Article 3. So an instrument can be issued for value to avoid the normal penalty of fraud. So if they issue a bill, if we get a bill, right? So let's say anybody sends a bill, they're actually acting as or on behalf of the United States or the government or these. So it is already implied, and it must be implied, that there is some value to it, or they're asking for value. So that way it has to be accepted for value and transferred for value. But they run the risk by doing that, because if they do that, which they always do, and we do the right thing, and we accept it for value and return it for value, they now have to close the account. But how we do that is very important. How is that done? Okay, so it is the transferee's choice as to how it will all turn out. He determines if the instrument is a promise or an order, if it is negotiable or non-negotiable, and if it is a payment or a security for an antecedent claim he has against the issuer, or if it is a security for an antecedent claim the issuer has against him. His endorsement will inform the issuer of what he intends to do. He has the option of accepting it for value and settling the account to close the books. He can even send an additional promissory note with the return of the instrument he has accepted for value. Isn't that interesting? Hear that? He can even send an additional promissory note with the return of the instrument he has accepted for value. It would not hurt for him to do this, so the United States does not suffer because of the actions of one of its agents. If he refuses the instrument for cause and returns it, it is possible one of those agents will cause the United States to suffer a financial loss. It might be better to be seen as one who aids and assists the United States in the time of emergency rather than one who does not. Yeah, because what we're trying to do is we're trying to be, aid. We don't want to fight them. We don't want to be, enemies. So if we're giving value, a promise to pay, if we're giving something, obviously, that's a good thing. We're trying to help. Now, if that one employee receives it and don't know what to do, they're uneducated or incompetent or don't know or never heard of this. Well, obviously, if you know what to do, if you know you've issued a promissory note along with the instrument, then you can enforce it. You can take it all the way, and it would just be an unfortunate mistake which one of its agents has made. Section 3 of 3-303 deals with options the transferee has when an instrument is issued for value and transferred for value to him. UCC 3-303 value and consideration. An instrument is issued or transferred for value if the instrument is issued or transferred as payment of or as security for an antecedent claim against any person, whether or not the claim is due. UCC 303 says an instrument is issued or transferred for value if it is issued or transferred, one, as if it were a payment of, or as if it were a security for an antecedent claim against any person, and it does not matter if the claim is due. The antecedent claim against any person can be, and usually is, the claim international lenders have against the United States. US citizens are sureties for that debt, and the United States is the principal. When a surety is called upon to pay his principal's debt, a demand for payment has already been made of the principal. For whatever reason the principal did not pay when the demand was made, so the attention then turns to the sureties. The sureties are required to pay immediately. Since United States citizens have not expressly signed on as sureties for the United States, demand can only be made for value. The United States, acting for its creditors, can make demands for value, i.e., for loans. When the surety, transferee, receives a demand for value, the demand needs an endorsement to make it negotiable. The issuer is looking for the transferee to supply the endorsement. That can be a blank endorsement or a qualified endorsement. It is your choice. That's true. The instrument can be issued or transferred for value as payment or as a security. The endorser decides which it is. The antecedent claim can be against any person, not necessarily against the transferee. That any person can be the United States for the national debt if the transferee is a surety of the United States. If the transferee agrees to be surety, he has an obligation to pay the instrument immediately. If the transferee gives the instrument to the man who represents him, he can use the commercial rules of A for V, the instrument the instrument and return it for value and for closure of the account. Either way, the transferee has an obligation to do something with the instrument. Gotta perform. Gotta perform. Giving value. From 1-201 is not the same as transferring for value from 3-303. The transferor, meaning the issuer, in 303 usually wants to get a valuable consideration back for an instrument he issues for value. And he wants a new contract on which he or the person he represents is a creditor. An issuer for value has no pre-existing contract and no antecedent claim that authorizes him to issue an instrument. So he issues it for value and delivers it to someone, which is the target, with the hope that the receiver will accept it without conditions. The one who receives an instrument issued for value does not have to accept the liabilities attached to it, unless he has an obligation to accept the liability. If there is no obligation, the transferee can view the instrument as payment and return it with proper endorsement to pay the instrument and close the account. The instrument pays the instrument. The issuer pays the issuer. Confusing, isn't it? The instrument can also be an offer to contract, and no one is required to contract if he does not choose to do so. The presumption that everyone is obligated to enter these contracts is based on an implied simple contract. That is not a very strong position. When an instrument issued for value is received and retained, it is accepted as though the receiver has given it a blank endorsement, and the transfer of liabilities has been successful. A blank endorsement waives all the defects. And the main defect in an instrument issued for value is that there is no security attached to it. So see, there's no security. If there's no security attached to an instrument, that's a defect. If it were not for the inherent security interest in the instrument itself, the whole project would be fraud. So that means there has to be an implied security interest in that instrument. So by accepting it for value, accepts or does away with the implied um, interest, and it just makes it it acknowledges that there is an interest in that instrument. Okay, so the issuer is not giving value; he is seeking value. The issuer is not giving consideration; he is seeking consideration. So they need us. When they come to us, they need us. It's like, please help us pay this debt. You know, so we gotta use the citizen as surety and perform. These abnormalities can be cured if the transferee gives it a qualified endorsement as a payment and returns the payment for closure of the account. After acceptance through a blank endorsement, the issuer's consideration is presumed and the endorser is liable on the instrument. A commitment, implied or expressed by the transferee, to take on the liability through a general acceptance would be a valuable consideration on his part and would result in a binding contract. He is then obligated on the instrument to make immediate payment. Subsection 4 of 3-303 deals with negotiable instruments. The issuer is seeking a negotiable instrument in return for an instrument he is transferring to the transferee. In most cases, the transferee does not know that the instrument itself is going to be made negotiable. The transferee is the only one who can decide what endorsement is going to be on the instrument. UCC 3-303 value and consideration. An instrument is issued or transferred for value if the instrument is issued or transferred in exchange for a negotiable instrument. UCC 3-303A4 says an instrument is issued or transferred for value if it is issued or transferred in exchange for a negotiable instrument. The issuer wants to exchange his instrument for a negotiable instrument. You can send him a check, which is a negotiable instrument. You can retain his instrument, which is an acceptance, waiving the defects and giving it a blank endorsement, which makes it a negotiable instrument. You can return his instrument as a payment with a proper endorsement, which makes it negotiable. The issuer gets what he wants, sort of. At the time an instrument is issued for value, it has no value until the transferee endorses it. Makes a lot of sense because the signature gives it the value. When you endorse it with a blank endorsement by mere acceptance, you have turned it into a negotiable instrument and you are the new issuer. The initial issuer now has a security interest in your negotiable instrument and he can negotiate it for payment. He is entitled to enforce the instrument instead of you. When an instrument is just issued, whether it be a check or a promissory note, it has value because it contains an order or a promise and is backed by a security, some sort of promise. Checks are backed by digits in an account that represent Federal Reserve notes, which are obligations of the United States. That's true. Promissory notes are backed by the promise of future labor. In the case of a check, the value is the promise on the part of the issuer and the order to the third party to pay it. If you cannot tell on the face of the instrument if it is a promise or an order, it can be treated as either. When the payee receives a check, it is a promise. When he negotiates it by endorsing it and then delivering it to a bank, it is an order. If the check is negotiated at the bank on which it is written and there are sufficient digits on the account to cover the check, that bank can take the instrument and does not have to take it for value. If the check is negotiated at a different bank, the bank can take the instrument for value because it does not know if the check is good. It does not know if it can collect on the check. If the bank gives its depositor cash immediately upon the deposit, the bank may not be able to collect from the maker's bank. It would then have to retrieve the value of the check from its depositor. To avoid such problems, the bank will usually give notice that the funds will not be available to its depositor until the bank has collected on the check from the maker's bank. In that case, the bank would be taking the instrument for value. That makes sense. It would be seeking value and would not be making a commitment to honor the check unconditionally. If someone just accepts an instrument issued by an agent of the United States for value and does not immediately pay it, he's in default. If he were to accept it for value and return it to the issuer's banker, meaning the Secretary of the Treasury, with a qualified endorsement, not a blank endorsement, the issuer would have no recourse against the one who endorsed and returned the instrument. The qualified endorsement is accepted for value, exempt from levy, signature, date, exemption identification number, which that would be the certificate number, which is a birth certificate registration number, I believe, deposit to the U.S. Treasury and charge the same to, well, that would probably be the insurance policy, which is the Social Security with no dashes, I would assume. The value of the instrument can be charged to John Doe 123-45, and if it is the birth certificate. The value can be charged to a clerk of court for case number such and such. It can be charged to the commissioner of the Internal Revenue Service for account 1234567 if it is a tax bill. Electric bills have a bank routing number and amount of the voucher printed in the magnetic ink right on the bottom of the bills. The utility companies are actually sending you the voucher to pay the bill with the statement every month. Even so, they might decide to turn off your service if you do not send them a thank you check in addition to returning the voucher with your proper endorsement. IRS also sends the voucher on the final demand before lien or levy. A voucher can be a written record of expenditure, disbursement, or completed transaction, or it can be a written authorization of or certificate, especially one exchangeable for cash or representing a credit against future expenditures. It would need to be endorsed before submitting it as credit. A blank endorsement puts the liability on the endorser. A qualified endorsement puts the liability on the issuer. So if we do a qualified endorsement, it puts a liability on them. They got to perform, they got to pay. Why? Because they received the interest. They received the interest that was already implied in the instrument when it was issued to the transferee. Until someone gives an endorsement, an instrument issued for value is not negotiable. If the transferee makes the instrument negotiable as a security with a blank endorsement, the transferee must pay it. Hold on. Let me put somebody on here. Okay. Where are we? He can give it a qualified endorsement by accepting it for value to make it a payment. When it is subsequently presented to a third party, which is a banker, it is an order from the maker to the third party to pay it. The instrument issued for value becomes the very payment that pays it. If the transferee gives it a blank endorsement by his silence and does not return it with his check, he makes the instrument his promise and also makes the instrument negotiable as a security. Whoever has a right to enforce it can negotiate it. If the transferee has no idea what to do with it, he might inadvertently make a security and commit himself to pay it. It is his choice. There is a price for ignorance. Ignorance is not stupidity, it is simply a lack of knowledge. If an instrument is issued and transferred for value, the person who is the transferee can make it the issuer's note, which is a promise, and the transferee's draft order. The transferee can be the one entitled to enforce the instrument if he gives it the proper endorsement. If he does not, the transferer is the person entitled to enforce the instrument, and he will enforce it. A case designed to seize property of the United States citizen is called a penal action. It is not civil and it is not criminal. It is based on violations of statutes that were implemented to facilitate collections for United States citizens to pay the national debt. Libels for information are used to obtain arrest warrants from the clerks of executive courts so the proceedings can be commenced. These are not cases, they are proceedings. The Book 39 IRS arguments that don't work and why explains this process in much more details. It can be found at lulu.com. When an indictment, which is a true bill, which is actually a libel of information, or other bill is presented to a U.S. citizen by the United States, an obligation on a pre-existing claim against the United States, which is the national debt, is being transferred to the transferee, which is the surety, the defendant, or the debtor. The bill is issued for value. The endorser is expected to create the money, both for payment or for security. The United States wants the U.S. citizen to supply the value. There is no actual security, antecedent claim, or pre-existing contract behind it. No money is needed if the transferee treats it as a payment and sends it to the issuer's bank with a qualified endorsement. This puts the endorser in the driver's seat and makes him the party entitled to enforce the instrument. On the other hand, no money is needed if the transferee treats it as a security by giving it a blank endorsement and keeping or holding it. This puts the issuer or his principal in the driver's seat and entitles the principal to enforce the instrument. Since 1933, the only money in circulation is money of account that is created on demand. At the time it is needed to satisfy an immediate need. If a bill is issued with nothing to secure it, it has to be issued for value because the money to pay it, which is a promise to pay it back, has not been created. If the transferee receives a bill and does not pay it immediately, he's in default. Some say the reason it cannot be paid is because no check to pay it was included with the bill. The instrument is the check if it is taken as payment, made negotiable with a proper endorsement, and turned into a draft, which is an order. See, right here, he's basically explaining it. You see, he said the instrument is the check if it is taken as payment, meaning an implied interest and by acceptance, and then made negotiated with proper endorsement. qualified endorsement and turned into an order to pay. If the transferee accepts it for value and returns it to the issuer's banker, which is the treasury, as payment to balance the books and close the account, he is not in default. Since it was issued for value, transferred for value, it can be accepted for value. To be the holder in due course, the endorser must take or accept the instrument for value. See 3-302, holder in due course, above. Under Article 3, if an instrument is issued for value, it is also issued for consideration. The issuer either gives the consideration through the instrument or issues the instrument for value to receive consideration from the transferee. When an instrument is accepted, meaning taken for value, it can be returned to pay the bill, and the transaction is finished. All the required bookkeeping entries for an accrual bookkeeping system can be made based on the offer for value and the acceptance for value. This bookkeeping cannot be done if the bill is not returned with an appropriate endorsement, though. If the bill is not returned, the bookkeeper has an unbalanced account. All accounts must be closed at the end of business day in an accrual system. An unbalanced account necessitates entries into the accounts payable and accounts receivables ledger. If you are the cause of a payable, you are also responsible for the receivable. So, your retention of the instrument is deemed to be a blank endorsement. If you do not balance the account, an executive court will do it for you. It usually results in a statutory penalty being applied against you through the U.S. citizen you represent. That's very, very interesting. Subsection 5 of 3-303 deals with irrevocable obligations. The transferee is expected to enter that obligation voluntarily and take on the liability of both the instruments and the payment needed on the national debt. UCC 3-303, value and consideration. A, an instrument is issued or transferred for value if the instrument is issued or transferred in exchange for the incurring of an irrevocable obligation to a third party by the person taking the instrument. An instrument can be issued for transferred in exchange for the incurring of an irrevocable obligation to a third party by the person taking the instrument. This is a very easy to understand subject. If the issuer, being the United States, issues or transfers an instrument for value on behalf of a third party, which are the international creditors, and if he, the United States, is fulfilling a promise, a reorganization plan, on an antecedent claim, which is the national debt, the third party, international creditors, have against the issuer, the United States, his purpose is to exchange the instrument for an irrevocable obligation, the United States obligation, citizen obligation to that third party by the person taking the instrument, which is the U.S. citizen. So basically, they're just passing on everything to the United States citizens because the United States citizens are its sureties. And the United States is the principal. If the transferee, the United States citizen, has an obligation to the issuer, the United States, and the issuer can provide the third party, the international creditors, with an irrevocable obligation by the transferee, the issuer has a defense because of the giving of value, which is the U.S. citizen's irrevocable obligation to the third party, the international creditors. The transferee, meaning the U.S. citizen, obligation to the issuer is transferred to the third party as value, payment on the national debt. The issuer, United States, is entitled to enforce an instrument, which is a pledge, it supposedly previously received from the US citizen. The transferee on the instrument issued and transferred for value is the one who decides if the instrument is a payment or a security. That- All right. The definition of a negotiable instrument says a person entitled to enforce the instrument may treat it as either UCC 3-104, negotiable instrument. An instrument is a note if it is a promise, and it is a draft if it is an order. If an instrument falls within the definition of both, a note and a draft, a person entitled to enforce the instrument may treat it as either. So, when an issuer of a negotiable instrument delivers it to a United States citizen represented by a knowledgeable man, it is the transferee, US citizen, who is entitled to enforce the instrument, since he has been asked to take on the liability. He is the one who decides if the instrument is a promise or an order. He is the one who has the right to endorse the instrument. An issuer of an instrument for value is gambling when he delivers an instrument to a transferee. If it gets into the hands of a knowledgeable man, the issuer might end up being the liable party instead of the transferee. Since agents of the United States who have authority to issue and transfer instruments for value are bonded, their issuance of these bills will not affect their personal holdings. But if a knowledgeable man accepts it for value and returns it for a closure and settlement of the account, and the agent is negligent or abusive, his bond may not cover his willful default. His only recourse is to try to get you to change your mind or waive your settlement. If you do not really know what you have done, it will be easy for him to help you waive your settlement and revert back to being liable on the instrument that you turned into a negotiable instrument. That instrument, as a security, can be transferred to a third party as a firm of satisfaction by the United States using you as a responsible party. An instrument that is a promise or an order can be issued for value by the agency or instrumentality of the United States, an individual, or a corporation, and delivered to another person who is presumed to have previously made a pledge to be liable for such instruments. It is not the instrument that determines if it is a promise or an order and a payment or a security. Whether the instrument is a promise or whether it is an order is up to the one who endorses it. Whether it is going to be used as a payment on a pre existing claim or as a security for a pre existing claim is also up to the one who endorses it. It is going to be negotiable, but when it is issued, it is not known who is going to be the liable party on it when it is negotiated. Endorsing a check issued as a promise and as an order is not done for value. Only instruments that are issued and transferred for value can be accepted for value. A check does not fall into that category. But the way it is endorsed does determine if the negotiation of the check will be a taxable event to the endorser or not. If it is endorsed in blank and deposited anywhere in the United States, a tax is owed. The person receiving it creates a record of the creation of a new security at the bank where it was deposited. That record confirms the person making deposit has realized an undeniable ascension to wealth over which he has control, and that transaction is a taxable event. A blank endorsement is one that that only exhibits the signature of the endorser and does not contain special terms. An instrument with a blank endorsement becomes a bearer instrument and can be enforced by anyone who has it. If it is given to a bank through a deposit, the bank becomes a person entitled to enforce the instrument. Using a check as an example, if it is endorsed in blank and deposited, its value should be included as income on a tax return. The same check could be endorsed with a qualified endorsement indicating the check is exchanged for credit on account or is exchanged for Federal Reserve notes that have no redeemable value according to 12 USC 411. The endorsement words are chosen by the endorser. They might be deposited as credit on account or exchanged for Federal Reserve notes with no redeemable value. If the bank has a problem with that wording, it might be changed to deposited as credit on account or exchanged for reserve notes pursuant to 12 USC 411 as amended. The amendment that is important is the one that removed the redeemability from its statutes. Interest in property. This is a good one. Interest in property. Since the United States money system is based on interest in property rather than substance, the commercial goal is to get a security interest in something that has value, not to take possession of a thing. Ownership carries liabilities. Interest in property does not. It is more efficient commercially to have a security interest in property than to own it. A security interest is not given unless there is an obligation that necessitates such an action. That means there is a debt involved when there is a security interest. When one applies for credit, he simultaneously gives a security interest in a thing that has value. That thing can be a title to land or a title to a car, title to a deposit account at a bank, a promise of future performance, or it could be a commitment on future labor. The security for the credit can be implied and constitutes consideration. This implies the existence of a contract, even though it may be a simple contract and you may not have intended to enter into a contract. Default on implied contracts can result in consequences anywhere from seizure of pledged property, which are titles or even a body, to negative information on a credit report. The blank endorsement of a transferee who does not do anything with an instrument that was issued or transferred to him for value is assumed. At some point, he is a holder and is liable, but the liability is not enforceable until there is an endorsement, which can be on another piece of paper that is attached by a connective note, or can be just presumed according to commercial law. Someone other than the transferee can even sign it on behalf of the transferee. This is not done unless the transferee is arguing or continually objecting to be billed. Technically, the transferee is in default, so his negligence or disobedience can be cured by someone else. But there is usually an additional price to pay at that point. An actual endorsement that fits the commercial requirements might even be on a paper used in a penal action proceeding called Terms and Conditions of Release. It is a special bond used in penal action courts when the defendant refuses to take responsibility to close the account. UCC 3-203, transfer of instruments, rights acquired by transfer. C. Unless otherwise agreed, if an instrument is transferred for value and the transferee does not become a holder because of lack of endorsement by the transferor, the transferee has a specifically enforceable right to the unqualified endorsement of the transferor. But negotiation of the instrument does not occur until the endorsement is made. This is a confusing section of the commercial code. The positions of the transferor and the transferee switches when the original transferee fails to respond. The mere act of retaining an instrument implies its general acceptance and its reissuance with a blank endorsement. Let me say that one more time. The mere act of retaining an instrument, meaning holding back the instrument, implies its general acceptance and its reissuance with a blank endorsement. This turns the table. It turns the original transferee into a new issuer, transferor, and the maker or drawer of an instrument. The original issuer becomes the transferee. For example, according to 3-203, the U.S. citizen who received the instrument and was originally the transferee with an automatic security interest in the instrument that was issued and transferred for value, he now becomes the new issuer and the transferor if he just receives it and retains it. The United States agent that originally issued it for value and had the liability to pay it becomes the new transferee with a security interest in that instrument. The new transferee has a specifically enforceable right to the unqualified endorsement of the transferor. All the United States has to do is get the U.S. citizen to sign something, anything that is related to that instrument. It could be the green card on a certified mail envelope or payment agreement with the IRS or terms and conditions of release bond in an executive proceeding court. Settlement. Handling negotiable instruments is just the first step of settling commercial accounts in the United States. Article 3 of the Commercial Code is the guidebook for dealing with negotiable instruments of all kinds. Registration and bonding through the Secretary of Treasury as your fiduciary and your securities intermediary and setting off commercial charges is needed to actually settle the account. You hear that? So this is very important. This is one of the first steps that would uh, would be very important, right? We gotta make them the securities intermediary. Direction for registering a security interest is found in Article 9, and the duties and rights of parties to securities are covered in Article 8. Knowing what A for V means is just the beginning. All right, guys, we're about to finish right here. A for V recap. Acceptance for value is purely a commercial remedy. It is not the only remedy. Acceptance for value is based on contract law and international law. Even simple contracts must have consideration from both sides to be valid. Bankruptcy law and insolvency law overshadow all commercial debts in the United States. The president is the only officer of the United States who has a constitutionally required oath. People are beneficiaries of the trust created by the Constitution. The president is the executive trustee of that trust. Acceptance for value is different than acceptance. Value can be a commitment to extend credit. It can also be as a security for satisfaction of a pre-existing claim. It could also be an acceptance of delivery on a pre-existing contract. It can also be any consideration sufficient to support a simple contract. Mere acceptance waives defects. Accepting an instrument for value gives the acceptor options. The issuer of an instrument has the liability on the instrument. An instrument issued or transferred for value is: one, for a promise of performance, to the extent the promise has been performed. Two, to acquire a security interest or other lien in the instrument other than a lien obtained by judicial proceeding. Three, as payment of or as security for an antecedent claim against any person, whether or not the claim is due. Four, in exchange for a negotiable instrument, or five, in exchange for the incurring of an irrevocable obligation to a third party by the person taking the instrument. One of an acceptor's option is to accept for value and return for value to the issuer's banker. Article 8 of the Commercial Code directs the handling of securities in the United States. A securities intermediary has obligations to the entitlement holder. Consideration means any consideration sufficient to support a simple contract. An issuer of an instrument for value has no defense to the obligation to pay the instrument. The issuer has a defense if performance of the promise is due and the promise has not been performed. An instrument issued or transferred for value is also issued for consideration. A person gives value to receive rights. He can acquire rights: A, in return for a binding commitment to extend credit or for an extension of immediate credit. He can also acquire rights as a security for or in total or partial satisfaction of a pre-existing claim, or he can acquire rights by accepting delivery pursuant to a pre-existing contract for purchase, or he can acquire rights generally in return for any consideration sufficient to support a simple contract. Acceptance for value is the same as taken for value. Instruments issued for value have no value in them until they are endorsed. A blank endorsement makes the endorser liable on the instrument. A proper qualified endorsement can make the endorser a holder in due course. An endorser is not required to take on the liability of the instrument. An endorser has the option of limiting or precluding recourse against themselves. An endorser decides if an instrument is a promise or an order. An endorser decides if an instrument is negotiable or non-negotiable. An endorser decides if an instrument is payment or a security. Interest in property establishes a claim that can be enforceable by a holder in due course. And lastly, interest in property does not carry liabilities of ownership of property. Well, there you go, guys. We have read acceptance for value. We have gone over it. Obviously, we need to go over it a little bit more. I highly recommend you go over it with a law dictionary, piece by piece, little by little. Right now, just me reading this, it's just a lot more came in. I have a lot more to think about, and that took us. Wow, it took us a while. So guys, thank you so much for joining. Anybody want to mention anything? Anybody want to say anything? It is.
Thank you.
You're welcome.
So I um so like value acceptance for value is like acquiring.
Um, so from what I see, from what I can understand, is like
Acquiring.
acceptance for value kind of puts it kind of establishes some things. One is that, first of all, the issuer, when they send us a bill, it is actually going back to the obligation, the antecedent claim, which is the national debt. There's a debt involved, right? So they're issuing the bill. They're the ones creating the
Right.
debt. So when we receive it, we're getting is them asking us to give it value. So they're looking for value. They're looking for consideration because they don't have it. So when we accept it for value, we're giving it value. Because why? The signature is going on there, right? The signature is going on the instrument. Now, depending on how we perform on that acceptance, how it is endorsed, then it is going to determine, right, the rights and remedies, or how it's going to proceed. But acceptance for value actually, it seems to establish that what you're receiving is a security interest, and you're giving back the security interest, you're giving back the value, you're giving back consideration. Now they are obligated because the interest is payment. So now we accept the security interest. By acceptance for value, we return the security interest, and that's the payment. Now they are obligated to perform. So how do we go about doing that? And I like that it mentioned, it didn't go more into detail about the tax, but it appears that the tax department is what we can use to help us with all of that. That's what it appears, that the tax department can help us with all of that. And we're probably gonna get into that on another session. But
Wait,
yeah.
and then I think no, it's wait, is so acceptance for value is actually like control, right? Being in control.
Yeah, remember, because according to what this is said, is that the only way really you can, there's no gold and silver, there's no substance. So the only way you can actually control things is to have a security interest, meaning that you
Right.
have rights to that interest. So
Right.
when you go and let's say you want to collect something, the only way you can collect it is if you have rights to collect it. But how do you gain those rights to collect it? Well, you would have to have a security interest in it. Now you could either collect it yourself, having the security interest, or you can give that security interest to a third party, another party, and have them collect it, right? But having the security interest is what we want, first of all. So by them sending us the bill and we do an acceptance for value, we're accepting it on the implied action that there is a security interest attached to that instrument. Although it doesn't say there is an interest in it, sometimes, like for example, the birth certificate doesn't say there's an interest involved in it, but it's implied. So if we accept it for value and return it, we are actually creating that value, because they don't have any value. We're creating the value and we're returning the value over to them, right? So now, yes, it is control. And again, it is not us, the living, it is the surety. We just speak on behalf or sign on behalf of that. We are never going to be recognized as living men and women. We're just going to be either good or knowledgeable representatives of the surety, or incompetent representatives of the surety. But one way or another, they're going to get what they need to cover the national debt, because there's already an implied agreement that the reason that we're using the all caps is to acquire the right to set off. So we're gonna give them value. So basically, it's like how Eric says a lot. He says how monetize the labor. You monetize that. But yeah, so when we receive the instrument, it's implied that there's a security interest and they're offering it to us. So if we sign it and we know how to accept it for value, we can transfer it back to them and have them use that interest to set off the account, because the interest is what pays for things. The interest is payment. There is no gold, there's no silver, there's just interest on the property and the asset that is being utilized. So there's an interest involved. It's very interesting because we can go back to the law merchant that we read a few weeks ago, and we see how we can acquire that security interest, how it is done through the contracts. But yeah, very interesting stuff, isn't it? Very interesting stuff. Let me show you this. Let's see if I don't know if I could do this. Let me see. I want to show you one thing before we go. Because right here in Belize, we don't have 1099A, which is a acquisition of secured property. We don't have that. So I figured I'd make my own one, right? I'd make my own one. Let me see if I can. I don't know how to do this. Let me see. Stop screen. I want to share this with you guys just really quick before we head out. Let me see. Share screen. Can't find it. I don't know how to do that. Oh, I can't do that.
But it was a lot of that was a lot of information.
It's a lot, huh? You got to go over it again, but because there's a lot of terms there that is very new to us. I won't be able to share it. Sorry, maybe next time. But a lot of information is new to us, and obviously we have to read it a few more times to get it. But it's basically like it's telling us on that document, acceptance for value, step by step. It's explaining how we have the right, by the use of our sureties, to set off the accounts. And remember, discharge a debt. Discharge means to extinguish, and debt means an obligation. So if I'm obligated, right, to pay a debt, so I have this receipt right here, right? This receipt has it has value right here, and it has numbers, and it says GST tax was paid. So this receipt is this has a receipt, and then it has this other piece of paper that was from a credit card or from a card. So this actually here is a promise to pay, and it could be an order to pay depending if we use a credit card or a debit card. A credit card is a promise to pay, a debit card is an order to pay. So by this attached to this, according to acceptance for value, that there's just a few things that we have to do to this to do some type of commercial transaction and where we're acting as a creditor. But I wanted to mention this. Hold on, let me going back to the tax. Where is it? So like this right here says GST 75 cents, and then it says, but the total is 675. So the GST right here has already been paid. The general sales tax, the tax has already been paid here. This receipt is evidence that this corporation right here received assets, received negotiable instruments, along with an interest. But they don't call it interest, they call it tax. So the tax has already been paid right here, and they have it. I have proof that they received it and the tax. So if I make an acquisition of secured property to the tax department, I'm letting them know that I received an income of 675, but I made a purchase of 675, and where the receipt demonstrates and shows that the tax has already been paid, they have the tax now. So by reporting the acquisition, we're transferring the tax obligation over to them, because we're reporting the assessment of the tax. So by just claiming by just going and making a how do you say it, by reporting the income. If we just report the income and never report what we did with the income, because we got an income, but then those things are assets too that we can use. So we use it by making purchases. And remember, purchase means the acquisition of securities for valuable consideration. So if I received $20 income and I spent it, I made a purchase with the grocery store, and there's a tax there. Obviously, there's an interest that's already in that transaction. They received it. They received that interest. So now they have it. So now I got to report that to the tax department and say, hey, I got an interest of $20. I mean, I got an income of $20. However, here's the acquisition, what I did with the $20. Give it over to them. And here's proof that they received it with the interest, which is the tax. It's already in there. Look, it's there. It's the evidence. So go get the tax from them. I'm done. I already did my part. So it's basically, yeah, I think that can be done with anything, with any purchase we do. But again, we need to research it some more. I'm going to be doing this tax next week. I'm going to the tax department with all these acquisitions and going to see what happens. But yes, guys, I'm going to probably call it a night. We've been here for like 3 hours and some change. So thanks a lot for sticking around.
Chanda, thank you very much. It's interesting how they made us only focus on the green promissory note, saying that's the only instrument that we have to, do these transactions. But, learning about all these negotiable instruments, that it's not that it's wrong at all. You know what I'm saying? Like, this is correct ways to process and to perform your situationship, and it's interesting to see how much information we got to keep, studying about and internalizing and understanding the principles of it, because we're amazed at like how amplified this world is in this whole instrument negotiable thing. You know what I'm saying?
Yeah. It also is very, very interesting to hear too that every transaction we're creating new money. We're actually creating new money as we go, because they have to close the accounts every day. And I always wonder about that, because I have family members that work at the bank, and they confirm, yeah, we have to close the accounts every day, zero it out. I'm like, zero it out? How do you zero it out if people are owing people? How's that work? What's happening is that they're just creating every day on an account new money. And as soon as they create a debit, that's what comes into existence first. So now they're looking for where's the credit going to come from? They're creating the debt. Where's it going to come from? So then somebody has to take the debt, the liability, take it, accept it, and then provide something to create the credits. So it's very interesting how that works, because we think that, we're going to go reclaim our securities and get all the money back from some account that has billions of dollars for us. That's what initially, when I came into this, that's what it was, like going around, everybody was thinking about that. But now we see that there is no money. We're creating the money as we go along. There's nothing. We're in bankruptcy. There's no money. It's all IOUs. It's all promissory notes. Right? So that's a very complicated thing to wrap your mind around.
Yeah, it's like a duality. It's like a duality.
Yeah, so like how he said, it was in what's happening right now is reverse. It's all reverse. So that's why it's a little bit tricky, like what? Wait a minute, what?
And the nation is in so much chaos and unbalance because of the lack of information. So, the more people that aren't really, walking in honor in all of this, that's why everything is just into more and more and more and more and more chaos.
Yeah,
because we should be aiding the debt of the United States or Belize, whatever, and for us to not be incompetent with what we're doing, and then we're not doing it. So the deficit is so high, like, and then there's no money because we create the money and then we don't clear it. We don't clear the debt.
Yeah. They're creating the debt, they're creating the debt on the basis that they have somebody who's going to pay it for them, which is the surety, which is our U.S. our Belize or U.S. citizens, our citizens. So that we get the debt because the principal, which is the government or whichever, United States, but they're supposed to pay, but they can't. So they go to the sureties. So it's come to us, the representatives of the sureties, and then now we have to figure out how to perform based on our knowledge. And it's a good thing that we're getting more knowledgeable, though. It's a good thing because I don't think the system is going to go away, the fundamentals of it, because it's always been here. Merchant law, it's the laws of how to manage the trades, and we're never going to stop trading. Never. And we're always going to monetize labor. That's just how it is. So I think it's amazing that we're learning this. And not a lot of people are going to find it interesting, which is okay. But the few of us who do, we now have responsibilities. We have certain responsibilities to do something good with it, hopefully, And this is just the start. I'm very happy you guys joined in. And I'm going to be uploading this to YouTube. And we'll see. Hopefully more people join in. It is a very interesting movement.
Very informative, a lot of information was put out.
Oh yeah, it's a lot of information. That's the third time I've read that document. Every time I read, it's like, oh man, I feel like I caught a little bit more. I'm like, oh shit, I gotta read it again. So yeah, man, I appreciate you guys for joining in. Thank you very much. And next week what we're probably gonna do, I'll keep you guys posted, but I wanted to share something with you guys. I'll see how it goes for me next week. But we're probably going to go into promissory notes, or maybe expand a little bit more on this acceptance for value and learning a little bit of how we create the money. I think it's very important to understand and try to talk a little bit more on how everything's reversed and how we can just utilize the surety that we have available for our commercial rights, which are remedies. We can utilize it. We have that remedy available, so let's use it. But like I said, I feel that the best thing is to try to acquire a new status, a different status for our commercial person. So like I just recently got the certificate of trust that I made. I had a living trust, and everything was transferred to the trust. I made a certificate of trust, and I also had I got the power of attorney from my mom of the estate of the registered certificated security, which is a birth certificate. I got the power of attorney for that. I did the claim. I sent out notices to the vital statistics, to the government here. I put it on the newspaper. I just basically say, hey, I'm making a claim to the estate Chandanmakhijani. You guys have 30 days to respond, blah blah blah. So I went through the whole administrative process of that. So I once I got that, then I basically transferred everything to the trust, and then I gave the trust power of attorney, or the estate gave power of attorney to the trust. So now the trust holds power of attorney of the estate. So that power of attorney is right here, right? Power of attorney. And then the let me show you, where is it? And then the certificate of trust, very simple, one page. I just took this and I took this, both of these, to the court recording office, paid the recording fee, right? And then the next day, got this, the certification that, well, it's basically a recording that Chandanmakhijani, the all caps, is now registered in the Living Trust, Master Chandan Living Trust. So he's a trustee of a living trust registered in the Living Trust, which now, which now, obviously now I gotta go notify certain persons, certain tax departments. I gotta notify them so that when they see certain instruments received or being received at their desk, obviously now it's coming from somebody who has the authority and the rights to deal with the trust assets. So now the assets can be now. Yes, I believe that Chandanmakhijani, as a representative of the trust, of the living trust, who owns all rights, titles, and interests of the estate, Chandanmakhijani, when there's a bill, like let's say a utility bill, is received, then as trustee and rights, having rights, can accept that bill for value, right? Because there's a security interest involved in it, and return it for consideration to set off and close the accounts, because they can use that now as an asset. However, I'm learning a little bit more of something that when it comes, like when we see the account, look at the accounting ledger. When to zero it out, if there's a positive number, to zero that out, you have to have a negative number there. And I'm learning a little bit more on how to send them notices and send them all these instruments, but to zero it out with that negative number, because we are getting the positive number. It's there. Okay, so we're going to give an asset, and the asset has to be conveyed, but it's going to be, they got to receive it as a negative, because they have a positive and we give them a negative, that's zero. So I know it sounds too good to be true, but to me, it's making more and more sense every day. But I'll let you guys know how it goes on my end, because here in Belize, it is very hard to talk to these people about it. But I'm sure I can get a discharge. I've not been able to get a discharge to them yet, but I'm on them. And with this court order paper right here, it's different, because right here, the people, they really do, when they see court papers, they perform. They don't mess around. They're scared.
They run quick.
Yeah, they are scared, of course. So we'll see how that goes.
Hey, but that's real cool, man, that you got those instruments not registered, but
it's recorded.
Recorded, yeah, you got them recorded, so now you can actually really do what you need to do, and if anybody's stepping your way, just sue them.
Take him to court. Take him to court.
Take them to court
With a smile, with all the paperwork.
Smile on your face.
How are they going to prove they got any interest and rights to the estate and the
show
assets
me
of the
the
estate?
bill. Show me the bill and show me the note.
Right.
You can't separate them.
Exactly. How are you going to tell me I don't have the trust doesn't have the right to negotiate its own instruments and to donate its instruments, to convey, to assign? Show me I don't have the rights. You know what I mean?
Yep.
So
exactly.
Very interesting stuff, man. And I'm going to put together a step-by-step how this can be done this way. Obviously, there's a lot of ways to do this. I just chose this way because to me it makes sense. And I want to put it together so I could share it with you guys. And if you guys choose to go this route, and you guys can maybe use this as a guide and use it use it for yourself if you guys choose to do it like that, right? No problem. Like I said, there's many ways of doing this. So I'll keep you guys up to date with that. So yeah.
Yeah, and I'll let you know on Tuesday, because I'm going Tuesday to go record mine.
All right.
So I'll let you know on Tuesday. I'll give you some information, and then we see where we go from there.
All right. Yes, man. And I know you've been doing your thing. So I know you've been doing your thing. So we're there. We're almost there, man. Don't worry. We're getting there.
Yeah.
I'll see you guys then.
Yeah. Alrighty. I'll say thank you for all the information, Chandan. And it's great. It's very informative, and it's great, and it just give you more momentum, because just by you reading it there, I get information, I get stuff and I got ideas,
Yeah. I know. Just going through this and reading it helps. We're not gonna absorb it all, but little by little. Who knows?
Yeah.
Maybe we could read it again some other time, and then just not so much. We read like few pages, and then like we dig into what these words mean, and just like try to understand it more, and try to understand who we are in this whole game.
Yeah.
Yeah. But peace and love to all you guys, man.
Good night,
We'll stay in
guys.
touch.
Yes,
Good night,
of
man.
course. All right.
Thank you. Good night.
You're welcome. Good night.